time list. Date code yaadu.
1st April.
Published.
Page number 18, serial number 57 to 61. Page number 19, serial number 62 to 66. Page number 20, serial number 67 to 71. Page number 21, serial number 72 to 76. Page number
21 entry ಇದೆ.
21, 72 to 76.
Sir, 21 is at serial number 74 to 81. What is wrong with you? Huh? ನೀವು ಯಾವತ್ತೋ ತಾರೀಕಿಂದ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ರ ಲಿಸ್ಟ್ ಮತ್ತೆ ಇದು ಯಾಕಿದು serial number page number 21 starts at serial number 79.6. Correct sir?
ಬೇರೆ ಲಿಸ್ಟ್ Page number 20, serial number 78 and 79. Page number 21, serial number 80 and 81. Page number 22, serial number 82 and 83. Page number 23, serial number 84 and 85. List number 1 for non-compliance, serial number 1. Manikanta
weeks.
HB.
Manikanta.
I appear for the petitioner, my lords. My lords, the office objection is that, my lords, in the cost title, my lords, in respond number 3, age has not been stated by me, my lords, and better copy of annexure B, my lords.
Yes, details of respondents to be stated correctly at prayer. Which respondent has to grant you the relief you are not mentioned?
My lords,
Please
I
correct.
had to state Tahsildar, my lords, instead as stated Superintendent of Police, my lords, at page 15, my lords, prayer A.
This is regarding appointment and compassionate grounds.
Yes, my lords. The father's, my lords,
Take out notice, but in the meanwhile you comply.
kindly, my lords, kindly, my lords.
But the AG is directed to accept notice for respondents 1 and 2. Issue emergent notice to respondent number 3. What is the interim prayer that you have sought for? Stay of annexure A.
Yes, my lords.
What has to be stayed?
My lords, the order wherein appointment was made to respond number 3.
The impugned order at annexure A is stayed till the next date of hearing. List on date put. Certified copy of
Great,
this order
sir.
shall not be released unless the office objections are complied. Yes.
Great, my lords.
24th April, serial for orders matter, serial number 2, Giridhar H.
H. Giridhar. List after receipt of the report of the police regarding service of notice to R2. Interim order and idea notice. Huh? Interim order granted or release extend till the next date of hearing.
Serial number 3, Rangnath S. Joyce.
Filing a memo, my lords, we have paid the
Number called the learned counsel for the respond number 3 and 4 has paid the memo and is enclosed there with a receipt for having paid cost of rupees 2,000. Ready na?
Yes, my lord, ready.
Ready?
ready, my lords.
We'll take it up then after the orders list are over. Orders in preliminary hearing movement on yes, pass over.
Please.
I
Serial
H.
number
Muralidhar.
4. Serial number
Paid the
4,
cost.
H. M.
Learned
Muralidhar.
counsel
Saturday we
for-
have paid, my lords.
Will the receipt?
Filing counter lacking.
The learned counsel for the petition submits that he has paid the cost of rupees 1,000 as per the order dated 24/3/2025. And ready na?
Lord,
Ready?
230.
Pass
This-
over.
But may I make one submission? Lord, this matter requires detailed hearing. Lord, if your lordship fixes a date, we'll file synopsis and argue it. It's only about, my lord, the creation of a new scale and then whether they are entitled to reversion to an old scale after having been promoted to officers.
When do you want it?
Lord, any date so that we can file our synopsis.
You
and then-
tell me what date you
Next
want.
week, any day.
Any Monday.
Lord, next week, my lord. Monday. Yes.
Monday is holiday.
Monday.
21st.
Very well.
List on 21st.
Serial number 5, Naik V.S.
In this case, I appeal for the respondent. Lord, sorry to Lord, the matter, Lord, the file entire has been handed over to my Lord client. So he's already engaged one more advocate. He will go on to file Mr. Lakshminarayan. That is what my instructions. So
Mr.
let
Which
it be called after 2 weeks.
Yeah, Lakshman initial in.
I don't know, Lord. Only the Lakshminarayan they have told. So
A
they
memo for retirement is filed by the advocate for respondent number 2 and ಇದು ಮಾಡಿದರೆ ಅಂದ್ರೆ notice
it's
ಕೊಟ್ಟಿದ್ದಾರೆ.
only in respect of gratuity. That's
Since along with the memo, an acknowledgement issued by the respondent number 2 for having received back the file is enclosed. In view of the same, comma, the learned counsel for the respondent number 2 is permitted to retire. Office is directed to delete the name of the counsel for the respondent number 2 from the cause list and show the respondent number 2. Show the name of the respondent number 2. Learned counsel for the respondent number 3 seeks time based on
21st April. Serial number 6.
Obliged.
Padmanabha R.
Padmanabha R.
for petitioner, my lord. Ready, my lord.
Copy served through RPD acknowledged to be filed. ಏನಿದು R2? Who is R2? Copy receive ಆಗಿದ್ಯಾ?
I received.
Statement ಇದು.
Yes, my lord. I received. I'm ready.
ಯಾರು ಅನ್ನಪೂರ್ಣ ಬೋರ್ಡರ್ಲೈ. Who is the contesting respondent?
My lord, management and commissioner, my lord, second respondent. Petitioner number 5, 6.
So who is the contesting respondent? Another petition number 5 ಅಂತ.
Sorry, respondent number 5. Respondent 5, 2 and 5, my
Who
lord.
appears for respondent 5? Syed
Not
Ruhullah.
appearing.
Mr. Syed Ruhullah.
I have served the copies of IA, my lord, through RPID, my lord.
There is no representation for the respondents as a first chance list on date. Mr. AJ
Third,
Srinivasan.
on submission, my lord. Now the vacancy is available for the petitioner.
ಆಯ್ತು ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕಪ್ಪ ಅಟ್ಲೀಸ್ಟ್ ಯಾರನ್ನ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಅದು ಯಾರು
No one is appearing from the date beginning, my lord.
they are appearing but if he is not appearing before the court
Fix
please,
any,
please inform him for list on ಯಾವತ್ತು ಬೇಕು
my lord,
21st.
please, my lord.
Yes, next AJ
Serial number
Srinivasan.
7. AJ Srinivasan.
Petitioner, my lord.
Who has to pay the cost?
The respondent, my lord. I had, I was
Respondent
ready.
number 3, my lord.
A Ramachandran.
Please.
I was ready to argue on the last date, my lord. The matter pertains to urban family welfare centers. The petitioners are all,
Ready?
My lord, what happens, my lord, in the central government
They
is,
are not ready.
central, no role of the central government regarding.
Right, pass
Please.
over it.
obliged.
My lord, pardon.
Vijay Kumar.
Number 8.
Last matter, my
7.
lord. Serial number 6, my lord. There is a vacancy for the petitioner, my lord.
21st argument,
Not
madam.
to post that.
No, 21st argument, madam. Yes, next. Vijay Kumar.
My lord, appearing for petitioner, kindly pass out. Cost also paid
First.
to library.
Learned counsel for the petitioner has paid the
1,000.
cost as per the order dated. So and so, 25/3/25. Ready now? Can I
Lord,
take
I'm
it up?
ready. I'm ready.
You ready?
So senior elder.
Alma ready na ilwa?
Ah,
Pass.
Good.
G
Serial number
Janardhan.
9. Janardhan G.
A memo is filed to withdraw the writ petition. In
Hearing
view
for
of the memo,
petitions, my lord.
dismiss ಮಾಡ್ಬೋದಾ? Petition is dismissed as withdrawn. Vaishali Hegde. Is it for withdrawal or disposal? You say
For
it is.
disposal, actually it's for withdrawal, because
Memo
they
is filed by the learned counsel for the petitioner to withdraw the writ petition.
please, with liberty to challenge the endorsement that they've issued.
With liberty to challenge the endorsement issued by the respondent number.
The
3 and
state,
4.
your lordship,
Huh?
the state endorsement dated, have produced it, 7/2/2025.
You not sought for liberty in this.
I've sought for it in the last
Stated
paragraph.
response have now processed the petitioner's case for granting grade pay of 9,000 and in view of the same and subject to consideration of granting the same, petitioner be permitted to withdraw ಅಂತಿದೆ.
No, I think that's a wrong file, Your Lordship.
ಯಾಕೆ ಏನ್ ಬೆಳಿಗ್ಗೆ ಏನ್ ತಿಂದ್ ಬಂದ್ರಿ?
8813 simple withdrawal ಅಷ್ಟೇ.
21.
10.
Can the endorsement issued by the respondent number 2. In view of the memo, the petition is dismissed. However, liberty as sought for is granted. Likhit RP.
Serial number 10. Sorry, serial number 11. Likhit RP.
In these matters, Your Lordship, on the last occasion, a division bench judgment was sought to be relied upon by the petitioners, Your Lordship. In this case, Your Lordship, actually the sericultural worker intermittently they were employed, the daily wages, a nominal muster role they were given, and the case that they are relying upon is not applicable in the facts and sir. There, he is a full-fledged employee, daily wager, full-fledged employee. Kindly see the division bench order, Your Lord. The employee.
Where is the judgment of the division bench?
Division bench.
Where is the judgment of the division bench?
Division bench, they are furnished on the last occasion, Your Lord.
100387, na?
6238 of 2020 is relied in that judgment.
Yes.
And there, ಫಾರೆಸ್ಟ್ ವಾಚರ್ ಅಂತಿದ್ದಾರೆ ಒಂದರಲ್ಲಿ. ಈ ನಮ್ಮ ಕೇಸಲ್ಲಿ R5 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ is squarely applicable. I have filed my objections and I have relied upon a Supreme Court judgment that is, I have enclosed it as annexure R5 of my objections. Because ಇಲ್ಲಿ the appointing authority is a commissioner for C and D post. It is a D post. ಅಲ್ಲಿ ಕಮಿಷನರ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ಇಲ್ಲೊಂದು ವೆಕೆಂಟ್ ಪೋಸ್ಟ್ ಇರಲಿಲ್ಲ ಅಲ್ಲಿ. ಹಂಗೇನೆ ಅವನು ಇಂಟರ್ಮಿಡಿಯೇಟ್ಲಿ ಸಿರಿಕಲ್ಚರ್ ವರ್ಕರ್ಗೆ ನಾವು ನಾಮಿನಲ್ ಮಸ್ಟರ್ ರೋಡ್ ಮೇಲೆ ಎಂಪ್ಲಾಯ್ ಮಾಡಿದ್ವಿ. ದೇ ಆರ್ ಕಮಿಂಗ್ ಸೇಯಿಂಗ್ ದಟ್ ದೇ ಆರ್ ಕವರ್ಡ್ ಬೈ ದ ಡಿಸಿಷನ್ ಆಫ್ ದ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಂಡ್ ದಿ which and another judgment of the
please tell us what are the facts of this case? Where was he working? How was
Sericulture department. They are working intermittently in Sericulture department.
Intermittently.
Seasonal work irutte.
So what is this writ appeal 100387 of 2013-23 ಎಲ್ಲಿದೆ? 100387 of 2023. Where do I get? On the last occasion, you made a mention that you will place on record some order passed in writ appeal 100387 of 2023.
My lord, that is 10038, that is
submission that some order is appeal 100387 of 23. And
that is the
has
division
some-
bench judgment of my lord Justice Narendra J. And matter went to Supreme Court and SLP dismissed. They have
100387. Where is that order? ಕೊಡಿ, ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ. Yeah, what are the facts of this case? ಎಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನು ಯಾವ್ದು ರಿಟ್ ಅಪೀಲ್ ಗೊತ್ತಿಲ್ವಾ ಅದು?
My lord, my personal papers, my lord, is last time ಇಲ್ಲಿ ಎಲ್ಲೋ misplace ಆಗಿದೆ. My lord, this gentleman, my lord, is working in the sericulture department.
We'll take it afterwards. Pass over.
Number 12. Satyanarayan.
A memo for withdrawal is filed. A memo to withdraw the petition is filed by the learned counsel for the petitioner. In view of the memo, the petition is dismissed as withdrawn. Liberty in it. It is always open for the petitioner to approach the appropriate court of law to challenge the impugned order.
Serial number 13. Manjunath Rao Bounsley.
Manjunath Rao Bose,
Petitioner, place time for
learned counsel for the petitioner seeks time after vacation.
Serial number 14.
For 1, 2, and 3 state was earlier annexure E. Judgment. It is covered by judgment.
Who is respondent number 3?
The audit accounts department. Earlier, in annexure E, your lordship will get,
Indian Audit and Accounts Department.
yes, the state government had appeared for the same cause of action, same facts, same grounds in annexure.
How can he appear, Mr.? Indian Audit and Accounts Department.
Your
how
lordship
can
may
he
kindly turn to annexure E. It was clarified and they appeared for the third respondent also.
Annexure?
E.
Page?
Page 91 onwards. In page 93,
ಇದೆ.
ಅವರು ಇದು ಇವ್ರಿಗೆ ಮೈಸೂರು ಯೂನಿವರ್ಸಿಟಿ ಮತ್ತೆ ರಿಜಿಸ್ಟ್ರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದೆ.
Correct, but you come to page 93, it says Rajendra Kumar Sungya for Indian Audit and Accounts Department. Come
ಅಲ್ಲಿ
to page 93, Mr.
ಅಲ್ಲ ಇನ್ನೊಂದು ಐ ವಿಲ್ ಶೋ ಯು ಲಾರ್ಡ್ಶಿಪ್ ದಿ ಅದರ್ ಪೆಟಿಷನ್ ಸ್ಟೇಟ್ ಇಸ್ ಅಪಿಯರಿಂಗ್.
That's a central government undertaking, Mr. How can the state government, the AG appear for? ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ.
Your lordship, interim order was granted in the first occasion in the similar petition by your lordship itself, which is also in annexure E, which is final judgment is also passed. And recently, Supreme Court has also held that they cannot recover behind 5 years.
What are the facts?
Of pension and salary amount pertaining to year 2006.
Retire?
They retired in different years. And there is a batch of petitioner in annexure E similar.
This is excess DA paid, is it?
Yes,
Excess DA.
yes. It is even recently 2 days back, Supreme Court has held that they can't. And this 3 coordinate bench of this honorable court have concurrently held that they can't recover.
And DSGI for the respondent number 3. Full stop. The next date of hearing, comma, the impugned order at Annexa
A series.
A1, A2, A3 are state. List on
23rd April. Serial number 15, Vaishali Hegde.
non-filing of expenses of R2 to R4. What about 2 to 4, 2 and 4?
Everyone has been served, Your Lordship. I have produced the acknowledgement. Your Lordship may kindly see. It's a case where third
Maharani
respondent,
Cluster University.
yes. 3 ballots.
What about 2 and 4?
I've served all of them.
Who represents?
There, Santosh Nagarale is appearing for the Chancellor.
Hmm.
Then Maharani Cluster College is K. Sridhar. They've all been served and the acknowledgements have been filed.
The Mr. Santosh Nagarale is directed to accept, office is directed to show the name of Mr. Santosh Nagarale
He was
as a
informed, Your
counsel for
Lordship.
respondent number 2
Two.
and
Your Lordship, K. Sridhar.
K. Sridhar for, he was here a while back.
Yes, they,
And Mr. K. Sridhar as the counsel for respondent number 4.
4.
List on.
Tomorrow, Your Lordship may kindly see the Vice Chancellor is sitting there without, which in contravention to the
Yes,
rules.
tomorrow.
Your Lordships, I'll undertake to file wakalat. The copy may be,
Name.
please.
No,
Advocate Vignesh Shetty.
Mr. Vignesh Shetty
It has
undertakes
been
to.
served, Your Lordship, personally, hand summons. And I've
I think she
produced the
has entered
acknowledgement.
appearance. Advocate Mr. Vignesh Shetty undertakes to appear for respondent number 3.
3.
This office is directed to show his name in the cause list. List tomorrow.
I'll file my objections if
When?
some time is granted.
When do you want?
Next week, any date.
No, Your Lordship may kindly see the urgency in the matter. I request Your Lordship to hear me before. The registrar has clearly stated that under 16(2),
Hmm.
the senior most dean has to be appointed.
Yes.
The third respondent is neither a dean and the appointing order states so. That she is the senior
But
most.
anyway, respondent number 3 is already appointed.
She is appointed, but then she cannot be continuing on the basis of this order.
Next week, any
Wednesday,
date.
Your
To
Lordship.
dispose it off. We can't.
No, yeah,
stay-
that's why Wednesday.
It's next
Simply
week, any
they're
date. I'll
sitting on
file
it.
my objections.
After being served, they're saying they're not being served.
So I'll file my
What is
this?
objections. Next week,
Friday,
any date.
Friday.
That's 14th.
Friday is a holiday, Your Lordship.
Hangire, ಯಾವತ್ರಿ?
That's why there is
14th
series
or
of holidays.
15th. Tuesday,
Tuesday. For consideration of interim prayer.
It is a holiday again.
15th.
Yes. 15th.
Monday is a
15th for
holiday.
consideration of interim prayer.
Monday is a holiday. Please.
Serial number 16, Rangnath AP.
AP Rangnath.
For the petitioner, my lord.
Your Lordship, for respondent number 7,
Yeah.
this morning I filed wakalat. Kindly have this matter by Wednesday, Your Lordship.
Respond number?
7.
All the responses are served.
All the respondents are served, my lord.
Just
Who
now I
will be-
received the wakalat for R4 and R5. CN Keshamurthy for R4 and 5.
Mr. C.N. Keshavamurthy
Keshamurthy for R4 and 5.
undertakes to appear for respond number 4 and 5. Mr.
R7 Prakash MH. Your
Mr.
Lordship.
M.H. Prakash undertakes to appear for respond number 7.
Please, Your Lordship.
And what about R6? Chairman Governing Council, Kempegowda Institute of Medical Sciences. ಅದಕ್ಕೂ ನೀವೇ
I
ತಗೋತೀರಿ?
undertake to file wakalat separately, madam.
R4 and
Because
4,
only
5 and 6.
Saturday evening they have served and summons, Saturday evening.
ಆಯ್ತಪ್ಪ 4, 5, 6 for Keshavamurthy.
Yes, madam.
What about R3, 4, 5, 6?
Kindly grant 10 days time, madam.
Lord, Wednesday, my lord. My lord, the R7 has already passed.
Tuesday.
Your Lordship.
Lord, permission to complete the office objections, my lord.
Complete today, otherwise cost.
Complete today.
The meanwhile, office objection shall be complete.
When date?
Yes.
Serial number 17. Mohan PS.
What are the office objections? Better copy of Annexure T to be filed. Annexure T. Office objections, serial number 1 is overruled. Yes.
The petitioner is appointed as an Anganwadi assistant in 2019. I had applied for the assistant post in 2019, but the appointment order was issued. Education qualification is the 9th standard on purely on merit basis. So by oversight, one Pavitra was selected in 2019 batch. So she had given a representation to the DC stating that I am owning maximum marks compared to Pavitra. So consider her representation. The Pavitra was removed and she was appointed in 2020.
Yes.
So she had lost 8 months from 2019 to 2020. Now the government has called for the application for direct recruitment for the Anganwadi teacher. So she is entitled for a promotion. The minimum is 5 years. So only 6 months hogidrinda, now she is not eligible for the promotion. So consider that representation.
It's only for a mandamus. What is the interim prayer you sought for?
Now they have called for the applications for direct recruitment through online and as per Annexure T.
But good. AGS director accept notice for response 1 to 5. Any appointment made to the post of Anganwadi
Teacher.
At which Anganwadi?
Mardi Panchayat.
At Mardi Anganwadi, na? Anganwadi Mardi.
Mardi village. Mardi village.
Mardi is Tumkur alla illi?
Illi Hassan district.
Hassan district. To the result of petition. Copy sir madi.
24th April.
Yes.
Notes the clarification notes with regard to notes the I have filed wakalat on behalf of petitioner 1 to 5 lords. As a lord GPA holder of the petitioners. Plus now lords during the pendency of the lords CRP. Lords they have engaged lords my learned friend. Lords that they were without terminating my GPM lords. Lords without lords they wakalat was not taken on accord during the pendency of the lords disposal CRP lords. Now lords application is filed. To the trial court, first appellate court. Not the only clarification is not from the stage. Not we have led the evidence not before the first appellate court. But from the very same stage, it has to be not the trial court has to proceed. Not.
What is the order?
Your Lordship may kindly recollect, a suit was decreed in my favor, respond number 17, or defend number 17, respond number 17 in RA. RA was allowed blood. I was not served with the notice. Based on that, I filed miscellaneous. My miscellaneous petition was allowed. Blood contending that that miscellaneous petition is allowed after 7 years. My learned friend approached this honorable court in CRP. Not CRP, my lords, were not pleased to dispose of by observing at the stage of RA. Not when the matter was the appellant had passed away, and a decree was passed in favor of a dead person. On that ground, your Lordship had remanded the matter. Now, my learned friend is apparently representing the dead person by holding GPA.
I'm sorry.
The original parties are here, represented by my friend Mr. Sangmesh. Either of them, your Lordship had indicated to them, sort out the issues between yourself before this can be proceeded with. All your Lordship may close this clarification application. Let them sort out with liberty to file a fresh application if they want.
Lords, we are not appealing for the dead person. Lords, all the petitioners are given GPA.
What is wrong in the order?
Lords, the clarification they need to lords. Lords, I will lords permit me lords to engage Senior counsel, my lords.
Senior counsel, okay.
From the stage on which, my lords, the IA was disposed of, my lords, that was the evidence stage, my lords. Plus, from the same stage, it has to be proceeded, it has to be continued, my lords.
Obviously, idenanthe ಹೇಳಿದೆ ಇಲ್ಲಿ, as rightly condemned, learned counsel petitions, the appeal filed is also decreed. Costed with judgment and decree shows that the notice to respond was held to be sufficient. However, respondent were too long thereafter, that is after nearly so continually came to the decree passed out to recent notice. Court cannot ignore the fact that the reserve petitions had expired on
Lords.
by the, without going to the merits of the country's other responsibility. No 6 months from the date of the circular. What is wrong in that? Whatever is there is there. What is not there is not there.
Lords, that is not clear, Lords, that from which stage the IA has to
Only
proceed, my
said, we have only said, because the the appellant in RA died, without bringing the LRs of the appellant, the court could not have proceeded. It's a decrease
Appeal
and
became
non-est.
abated.
So therefore, I only said, let the trial court decide the matter.
Lord, the clarity only if they got to, my lord, the stage, Lords, from which, my lord, the IA has to proceed.
Court will decide that. But IA 1 of 25 is filed by the power of attorney of the petitioner.
Yes, my lords.
Power of attorney of the petitioners
Cost rate la ಇದೆ.
to seeking clarification of the order dated from that this court by directing the trial court to dispose of the appeal as expeditiously as possible. It is contended that this court did not indicate whether the appellate court should proceed with from the stage at which it was stage just prior to the disposal of the appeal or not. Full stop. This court has noticed that the decree passed in RA 248 of 2011 was non-est, and therefore had directed the trial court to dispose of the appeal. In that view of the matter, the appellate court is bound to dispose of the appeal in the manner mentioned, in the manner directed by this court, 29/11/2023. Hence, IA 1 of 25 is rejected, but is subject to the observations
But
made
the
above.
appellate court, my lords, is not allowing us to lead the evidence, my lord, that is the reason, my lord.
Then you challenge that order. If the appellate court does not allow you to lead that, challenge that order.
Appellate.
J. Manand.
IA 1 of 25 is filed for early hearing. Since the petition is not admitted, IA 1 of 25 is rejected. List the petition of preliminary hearing in B group on date.
21st.
Yes, Mr. Narayan, but.
20.
Huh?
IA, my lord,
Ah,
is for a direction to pay the admitted gratuity. I had sought for stepping up. When I made a representation, my lord, they reduced my pay. I have retired from service. My lord, at least the admitted amount, my lord, let them pay.
I'll seek
That
instructions
suggestion
for
was-
her. Let be called on 15th, my lord. I'll
My
seek
lord, on the
instructions.
last occasion, for the very same purpose, my lord, this was adjourned.
ಏನ್ ಜೂನ್ ಇಂದ ಟೈಮ್ ಕೇಳ್ತಿದ್ರಲ್ವಾ?
Sorry, my lord. I'll seek it. I'll get it done. 15th, my lord.
The learned counsel for the respondent again seeks time. The request for time is not justified. Nonetheless, last opportunity is granted. List on
15th, my lord.
15th.
My lord, earlier interim order, my lord, was granted. Your lords may kindly extend.
Interim order granted on so and so date is extended till the next date.
21, Satish K.
Satish K.
Petitioner minutes. To the
Vacating
respondent
stay.
to my lordship.
You have filed this application.
This go to Kalguri bench.
Who has filed the memo?
Respond to file the memos.
This petition arises from where? Ballari.
ಅಲ್ಲ ಬೆಂಗಳೂರು ಟು ಕಲಬುರಗಿ ಬಳ್ಳಾರಿ
Bidar. Governing council be there Institute of Medical Sciences, you have to go before Kalburgi bench.
I'll take instructions, my lords.
We'll transfer it, madam.
Short accommodation, my lords. I'll take
Madam, ಸುಮ್ನೆ ಅದಕ್ಕೆ ಟೈಮ್ ಕೇಳ್ಬೇಡಿ. Respondent is in Bidar. Respondent number 2 is in Bidar.
Already one case is pending before.
What is challenged?
Joint inquiry, my lords.
Huh?
Inquiry, my lords. Joint inquiry.
Joint inquiry ತಾನೆ ಬರ್ಕೊಳ್ಳಿ.
One of the petitioner is in Ballari, my lords.
It doesn't matter, the issues, whatever issue that arises for consideration this petition must be dealt with by the bench in Kalburgi.
My lords, I'll take
The
instructions.
petitioners have challenged an order dated 5/1/2021.
This point number 1, my lords.
Disciplinary authority, annexure L. Appointing an inquiry officer to inquire into the principal bench and the bench at Kalburgi and Dharwad. This petition has to be placed before the bench at Dharwad. Consequently, Kalburgi. Consequently, the office is directed to transfer this petition to the bench at Kalburgi. Full stop. For statistical purposes, this petition is treated as closed in the principal bench. Yes.
Serial number 22.
Interim order may be continued, my lords.
Interim order granted early is extended till the next date.
Serial number 22. Kavita, petitioner party in person.
Kavita M.
Kavita M.
Yes. Ready?
Yes.
Pass over. Nanja Reddy PN. Pass over. Nanja Reddy PN.
PN Nanja Reddy.
Pawan Kumar.
2 days time.
In direction ಏನಿದು? What is this direction?
Last time they have filed objections, sir. It can be disposed of transfer matter.
What is this IA 1 of 25 for direction?
That to consider the representation.
Road posting health officer. Or ನೀವೇ ಡಿಸೈಡ್ ಮಾಡ್ತೀರಾ ನಿಮ್ಗೆ ಎಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತ?
ಮೊದಲೆಲ್ಲ ಇದ್ದಿದ್ದು the petitioner has been posted to a non-existing post. Last time
ಎಲ್ಲಿ ಕೊಡ್ತೀರಿ? ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟಿಲ್ವಾ ಇವ್ರಿಗೆ?
posting ಕೊಟ್ಟಿದ್ದಾರೆ to the non-existing post. ಆ post ಇಲ್ಲ ಅಲ್ಲಿ.
ಇಲ್ಲಿ ಯಾವ ಪೋಸ್ಟ್?
That post is there.
ಯಾವ ಪೋಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ?
ಮಿಲಾಡ್ NPCCH ಅಂತ ನ್ಯಾಷನಲ್ ಪ್ರೋಗ್ರಾಮ್.
ಒಳ್ಳೇದಾಯ್ತು, ಕೆಲಸ ಕಡಿಮೆ ಇರುತ್ತೆ ಆರಾಮಾಗಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ರೆ any day convenient.
Current counsel for the petitioner seeks time. List on
22nd April.
24
Vijay Kumar.
May I request lords for 1 week time for filing a rejoinder in the matter?
Lord, I have filed an application for vacating the interim order.
Matter relates to suspension, my lord. I have to
The order of suspension has been stayed by
file the
this honorable
objection.
court.
I need to file rejoinder to.
Don't
My lord, this will also set a bad example, my lord, for management not doing anything about it. All I'm saying is, my lord, whether he is guilty, not guilty is secondary. My lord, let the complaint be inquired into, and my lord, if he is continue aware, but order of suspension, my lord, should not generally be interfered unless it is, my lord, opposed to law. My lord, I am only saying.
I'll file my rejoinder to the objection submitted. Lord, kindly have it on Monday or Tuesday, my lord. Tuesday, my lord, on 15th.
And counsel for the petitioner seeks time to reply to the objections filed to the writ petition.
Lord, may I say, my lord, reply to application.
Reply to the application filed for vacating stay. List on date.
Interim order may kindly be.
Interim order granted as extent.
16th April. Serial number 25. Mahesh Kiran Shetty.
Petitioner in this matter. This is the petitioner is a BSc graduate. My lord, the subject in which he has studied is, my lord, science.
With your lordship kind permission, yeah, in pursuant to suspension order, we have revoked the suspension order. And
That's memo is issued.
Yes, please, madam.
Impugned is, my lord, he is suspended.
So
For the reason, my lord,
they revoked it.
no, what they do is they revoke it, and immediately after filing of this petition they revoke it, and thereafter, my lord, they transfer me to another place. Now, my lord, after during February 2015, my lord,
There's no
qualifiedness
file a separate petition if you want, but cool.
with liberty, my lord.
Petitioner has challenged the impugned order bearing number so and so dated 23/12/2024, by which he was suspended from service. When this petition was listed for orders, it is stated by the learned counsel for the respondent number
1 and 2.
1 and 2 that the impugned order of suspension of service of the petitioner is revoked, and a charge memo is already issued of the aforesaid, this petition has become infructuous. Consequently, the petition is dismissed as having become infructuous. It is however open for the petitioner to challenge any other order passed by the respondents 1 and 2 in accordance with law.
Please, my lord.
Serial number 26 Subramanya Bhatt M.
26 Subramanya Bhatt.
Lord, in this case, Lord, can I just file my rejoinder? Lord, I have served a copy on. Last occasion, my lord, I pointed, Lord, which is competent to, my lord, send me on deputation to this, as far as Annexure A is concerned, my lord, to corroborate my contention. But fortunately for me, my lord, after this deputation, my lord, things have taken a slightly different shape. Now, my lord, after I was deputed, my lord, please have a look at page 27. My lord, this is a notification dated 4/1/2025. Which the government has appointed me as a director, my lord, in exercise of its powers under Article 18B of the Articles of Association.
How does that matter?
My lord, this that, my lord, my doesn't have any authority or power to repatriate me. Now, my lord, my contention, my lord, further gets ratified, my lord, as far as Annexure D is concerned. Because now, my lord, I have been inducted as a director to the board of directors of Kavika.
That is okay. It's a government company. That's a different.
It's a government company.
Therefore, you're nominated.
Of association. Lord, I will straight away take your lordship to page 12, clause 8A and B of the Articles of Association. 8A. The directors appointed under Article and C below are not liable to retire by rotation under Section 255, nor be removed from office by a resolution of the company in general meeting under Section 284 of the Act. Then, entitlement of Government of Karnataka to appoint and remove the directors. So long as the governor holds not financial institutions mentioned and appoint other persons there too. So now by virtue of my induction as a director to the board, my contention is not further fortified by clause article 16 not in the next page. Delegation of powers to the managing director or in his absence to the executive director by the board. The board of directors may confer on the managing director or in his absence on the executive director such powers for such time to be exercised for such objects and purposes and upon such terms and conditions and with such restrictions as they may think expedient. Such powers may be exercised by the managing director or in his absence by the executive director, either collaterally with or in the exclusion of or in substitute, withdraw, alter or vary. Provisions make it abundantly clear that the managing director cannot claim supremacy or superiority over this petitioner.
In respect of a company.
No, maybe. Lord, in fact, as a matter of fact, Lord, an identical eventuality arose before the Honorable Division Bench. May I just pass on, my Lord? Lord, in that case, my Lord, sheet issued against employee of the, that is, my Lord, Karnataka Soaps and Detergents Limited, where then, my Lord, he was inducted to the board of directors as one of the directors. Then, my Lord, the managing director issues the order of suspension and also charge sheet. He, my Lord, I'll read, my Lord, paragraph 5. May I just read paragraph 5. As already mentioned above, the show cause notice cum charge sheet is dated 5/10/2004, but the appellant had been appointed to the board of directors of the respondent company on 25/11/2003 in terms of the approval of the government contained in Annexure B. Similar situation. Therefore, while the rules are reticent on the subject of the disciplinary authority, competent authority in respect of members of the board of directors, it is certainly clear to us that the managing director who, in any cases of equal status being a member of the board, in the absence of any indication in the rules, it could only be expected that the authority to decide of a board noted that the appellant had ceased to be a director of the board on 10/11/2004. But this fact, we say with respect, is not of relevance since the show cause notice had been issued prior thereto and in the duration of the appellant's appointment nomination as a member of the board of directors. Then, Lord, please have a look at paragraph 7. We are of the opinion board member, but having come to this conclusion, the natural corollary will be that the suspension order passed by the managing director then need to be filled up by deputation. That is what the cadre and recruitment rules say. So, my lord, both of us have been there on deputation. My lord, having regard to the law laid on in this writ appeal, my lord, the managing director cannot be said to be a superior to this executive director.
Appeal, what was questioned was disciplinary proceedings.
Maybe. My lord,
That is
ultimately
all.
the question fell for consideration is whether managing director is competent to do so or not.
Correct.
Here also, my lord, the impugned order of repatriation has been passed by the managing director, despite the fact that he did not enjoy the power to do so.
Yes.
Under the
How did you come in is what the question is. Were you appointed or deputed by the state government?
Yes, my lord.
Where
Because,
is
my lord, of course, no doubt, Annexure A does not indicate that, but merely the KPTCL has deputed me, but it is not assumption to be filled up by government. So therefore, but on the last occasion itself,
where's the C&R?
Lord, that I have produced. Please have a look at Annexure G, page 49. Forty-nine. Annexure G. First one is managing director, method of recruitment, deputation, then as decided by the government, method in the last column.
Yes.
Then my lord, number 2 is the executive director. Annexure A should have been, I am not in a position to produce that record. These files are well within the domain of the first and fourth respondent. Your lordship may be kind enough to summon these files.
Now you please have a look at the copies forwarded.
Yes, my lord.
Page 20. ವ್ಯವಸ್ಥಾಪಕರು ಎಲ್ಲಾ ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ಗಳು ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಮಾಹಿತಿಗಾಗಿ.
My lord, this is a passed, my lord, as a corollary of the decision taken by the government.
What is there to show that is what I am asking.
Lord, unfortunately, my lord, I don't have anything to show that. The whole file may be summoned, my lord, it is in the Kaveri Bhavan only.
Yes, Mr. Senior Counsel.
My lord, there is one more, if I am permitted, my lord, just one aspect. Lord, I will just rely on one judgment of the Honorable Supreme Court. Lord, this is 2005 8 SCC page 394. Lord, I will just invite my lord's kind attention to a very small paragraph, my lord, at para 32, at page 402.
Para 32.
Yes, my lord, 402. Ordinarily, a deputationist has no legal right to continue in a post. A deputationist indisputably has no right to be absorbed in the post to which he is deputed. However, there is no bar thereto as well. It may be true that when deputation does not result in absorption in the service to which an officer is deputed, no recruitment in its true import and significance takes place as he is continued to be a member of the in service. Despite a ordinarily is malified, an action taken in a post haste manner also indicates malice.
Yes.
My lord, I have alleged malified because, my lord, it is based on the complaint of the labor unions. My lord, this repatriation has been triggered. So for all these reasons, my lord, my most respectful submission is, my lord, first of all, my lord, it tarnishes my image. My lord, it imputes allegations on me. Yes. Then secondly, my lord, this has been passed by a person who doesn't have any power, authority or jurisdiction to pass this order.
Yes.
Now, my lord, to see whether this has been, the order of deputation has been passed in terms of the government order, my lord, my most respectful submission is, kindly someone.
We'll ask the other side.
Please.
Yes, sir.
Lord, my submission, Lord, is this. The entire case, my Lord, is based on.
It has to be filled up. Post of managing director and executive director, if it has to be filled up, it is to be done only by the government.
That is, my Lord, the cadre recruitment rules which he is relying upon applies to employees of Kavika. Lord, if an employee, the chief engineer in Kavika has to be appointed as executive director, then my Lord, that's what applies. Not for KPTC employees who may be sent on deputation. That's my Lord, who are posted. Wherever government permission was needed, specifically Ms. Ramaswamy, he is the petitioner. Then Manava Sampulmana Kendra Manavi Mangaluru, Karnirvaka Nideshakaru, Kavika Bengaluru, Niojane Merige, that means on deputation. Now, my Lord, please turn over. And now, my Lord, please see serial number 9. Munigopal Raju KM, Nirdeshakaru Tantrika Escom. ಕೊನೆ ಕಾಲಮ್ ಅಲ್ಲಿ ನಿರ್ದೇಶಕರು ತಾಂತ್ರಿಕ ಚಾಮರಾಜ ಸೋನ್ಸೋ ಮೈಸೂರು ಇಂಧನ ಇಲಾಖೆ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸೋ ದಿನಾಂಕ. That means energy department has to permit that. Then, my Lord, please see item 15 also. Next page 20. Jagdish S. ನಿರ್ದೇಶಕರು ತಾಂತ್ರಿಕ ಹುಬ್ಬಳ್ಳಿ ಅಲ್ಲೂ ಇಂಧನ ಇಲಾಖೆ ಅಧಿಸೂಚನೆ. Then, my Lord, there is no reference to government approval for this. Now, please see annexure A1. That is a charge which is taken. In the charge memo also, my Lord, he is saying, Nanu Dinanka, and he refers to this order only, and takes charge. So, at no point of time is there any record to show that government needed to give approval or have given approval. It was never the case. Now, my Lord, in the rejoinder, he files, my Lord, a document which he must, my Lord, explain number of documents which he has filed. Your Lordship will see, my Lord, he has taken out our records without permission and produced, my Lord, photostat copies of tender documents. I'll explain, my Lord, the tender document, my Lord, is self-serving document. Actually, what happened, my Lord, was the competent authority that was withdrawn, fresh tender was issued, and that the person in whose favor he said we are making some favoritism, he not goes.
Tell us, what is your
G?
Is that a C&R regulation?
My answer to annexure, respectful answer to annexure G is this, my Lord. Annexure G applies only to those who are employees of.
How is it?
I'll give an example. Supposing a person has reached the level of chief engineer in Kavika. He is born on the record of Kavika. He is there. Now they have to appoint. The next post is there is no higher post. So the next post will be executive director for him. For such appointments of employees of Kavika, you have to go to government and get approval. Not for deputation. Same thing with managing the deputation. Andre, my Lord,
call by deputation as decided by the.
That is, my Lord, if he has to go on deputation.
From government, no dispute.
So, my Lord, if there was no approval from government, then his appointment itself would be illegal.
Yes.
But he has been there.
He says that after the annexure A, it was approved by the government.
No, it's not so.
Or before the deputation, there was some proceedings.
It's not so, my Lord. That, in fact, your Lordship gave him time to produce anything if he can give it. Your Lordship produced annexure A. It doesn't say anything about government approval. And my instructions are, my Lord, government approval was not there. In fact, what happened, my Lord, was this. After, my Lord, joined her now, he produces one document on 3 annexure H, 3/3/2025.
How did he get this document? Obviously, my lord, he's taken it illegally. This is a letter being addressed by the MD to the government. ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಉಂಟಾಗಿರುತ್ತದೆ. ಈ ವಿಷಯವನ್ನು ಮಾನ್ಯ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಕೆಪಿಟಿಸಿಎಲ್ ರವರೊಂದಿಗೆ ಚರ್ಚಿಸಿ ನಂತರ ಶ್ರೀ ರಾಮಸ್ವಾಮಿ ಅವರನ್ನು 2025ರಲ್ಲಿ ಇವರನ್ನು ಸೇವೆಯಿಂದ ಪದವಿ ಮುಕ್ತಿಗೊಳಿಸಲಾಗಿ ಕಚೇರಿ ಆದೇಶ So information is given. 25ರಲ್ಲಿ ಶ್ರೀ ರಾಮಸ್ವಾಮಿ ಎಂಎಲ್ ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ಸೋಕ ಮಂಡಳಿ ನಿರ್ದೇಶಕರನ್ನಾಗಿ ನೇಮಿಸಿರುವ ಆದೇಶವನ್ನು So this reference, please see my lord 8B. 8B gives power to the government, which is in the same compilation lord at page number 12. And all directors of this company, my lord, are appointed by government.
Yes.
Lord 8A, which my learned friend, my lord, read, in the normal case, my lord, if a company which doesn't have this article, a person becomes a director, he can only be removed by a procedure known to law,
Yes.
which is either by rotation or by removal. Rotation is 255, removal is 284. What they're saying is that these nominee directors will not be liable to be retired by rotation or by removal by the general body. That is first. Then B, my lord, says, so long as the governor holds more than 51% of the total subscribed share capital of the company, government shall be entitled to appoint, subject to rights of financial institutions mentioned in 8C below, all directors for the time being shall be entitled to remove all or any of them other than directors appointed under 8C from that office at any time, appoint other persons.
Yes.
So on the passed an order
So,
withdrawing his appointment as a director also.
yes. It is after the suspension or
Yes.
the redeputation.
Yes, we have sent him back. Then a letter is addressed to government to say you had nominated him, so please exercise your power under 8B. The impugned order, my lord, is 11/2/25. 11/2/25 ಆದ್ಮೇಲೆ 3/3/25 is the letter, my lord, which he produces. Then, my lord, there is an interim order on 6/3/25. Thereafter, my lord, government exercising power under articles removes him. Therefore, my lord, my submission is that his contention that government only has to do it is evident amply from this subsequent development one. Secondly, my lord, his original appointment has not met with the approval of the government.
That we do not know.
That I am submitting, my lord, and there is no material.
Then you have to place on record how he was appointed.
He was appointed,
How he was deputed.
deputation, my lord, was done by KPTCL only, my lord.
Now, how can you do it is what I am asking.
The annexure A is speaking for itself, my lord. Annexure A is saying so. Annexure A, please see, my lord, 39.
Why don't you place on record the file relating to his deputation?
The entire annexure A file, my lord.
Yes.
Yes, we can place it, my lord.
That should be,
on
that should
record.
be done by the either by the government or by the fourth
KPTCL.
respondent.
KPTCL or Kudli. Now they say that there is no involvement of government. Let them place on record the file relating to
My
his
lord,
deputation.
this deputation order is passed by me, Kavika.
That is right. We do not know whether it is approved by the government, whether you sought for approval. We do not know whether it is post approval granted by the government. We do not know.
I am saying, my lord, I am stated on oath that this is not government approval.
Place it on
Please
record.
see my objections, my lord. I have stated so.
After hearing the learned counsel for the petitioner and the learned counsel for the learned senior counsel for the respondents, this court is of opinion that it is necessary to see the file relating to the deputation of the petitioner as the executive director of Kavika. List on
Give it tomorrow.
tomorrow.
Till tomorrow, my lord, interim order would
Interim prayer granted or release extend till the next.
expire.
Preliminary hearing matter, serial number 27, Aditya M.
Yeah, there is.
Appear for the petitioners, my lord. I'm ready for a hearing, my lord.
On board. Yeah, Hmm?
I appear for the,
Seal number 27, Aditya.
yes, my lord. I'm ready for hearing, my lord.
Yes, yes. Lord, AGS seeks time to file objections.
And short date may be given.
No, no, what is the petition about?
My lord, the petitioners here are the members of the Consumer District Consumer Commission, my lord. My lord, they were appointed. Subsequently, they got posting in Bangalore, my lord, and all other major districts, my lord.
Yes.
Subsequent to that, my lord, they were getting salaries to the extent of 6th pay commission, my lord. When the matter stood thus, my lord, the government of Karnataka issued a separate notification seeking the 7th pay commission, my lord.
Yes.
At that point of time, my lord, all the members, my lord, they
The
made a
matter requires to be
representation.
heard.
Yes, my lord.
List immediately after vacation.
Any day for
Just
convenient for
immediately
the court, my
after
lord.
vacation. Yes.
Serial number 28,
Grateful, my lord.
Ashwini O.
Ashwini D. B. Pramod.
Appear for petitioner, my lord. This is a case that seeking mandamus to consider my representations for compassionate appointment, my lord. My father was working as a Group D employee. He's worked for 34 years without any break, my lord. And he died in harness.
Hey, madam.
He died on 21/6/21, my lord. And I've 21 June 21, 2021, my lord. And I had given my application on 12/12/21, my lord.
It's not considered till date.
It has not been considered. In fact, it's been rejected, my lord.
Rejected, my lords. Prayer tav nodidre page 12 nodidre.
Annexure A ali.
Is seeking for a quashing the rejection, my lords. Annexure A.
What were you doing all these years, madam? 2 years have gone by.
I have been
Alla
called.
adalde ಇದು central government ಆಗತ್ತೆ. Central government ಆಗತ್ತೆ. He was working with the central government, my lords.
My lord, all
Application
these
was
years-
made, it was
CAT
rejected. CAT ಗೆ ಹೋಗ್ಬೇಕಾಗತ್ತೆ.
To go before the CAT.
My lord, I'm claiming a violation of my fundamental rights, my lord, because all these years I have been giving them continuous
Correct, but
representations,
then,
my lord.
madam, you sought for quashing some order rejecting your application for
Yes, my lord.
appointment on compassionate grounds.
Yes, my lord.
So there's a tribunal meant for all this.
In fact, a scheduled caste candidate also, my lord,
It
and my
doesn't
father.
matter, scheduled caste, scheduled tribe, minority, general merit, everybody should go to CAT. Just because you're scheduled caste,
That is only one of my grounds, my lord. In
scheduled
fact,
caste high court GM ಗೆ ಇದು ಅಂತಿಲ್ಲಮ್ಮ.
ಇಲ್ಲ, ಹಾಗೆಲ್ಲ, my
Don't
lord.
make this kind of submissions.
In fact, no, I'm in a very destitute position, my lord, which is why
That
I'm
is okay,
claiming
why you come to the wrong court is what I'm asking you. You should go before the CAT.
liberty may be granted for me to go before the CAT, my lord.
The petitioner has challenged an order rejecting her representation, rejecting his representation. Sorry, rejecting his application for appointment on compassionate grounds. He has also sought for a direction to the respondents to appoint him on compassionate basis. It appears that the father of the petitioner was employed at what?
Respond number 1.
It's the respondent number 1, which is a central government undertaking.
Respondent number 2, my lord.
2.
Yes, my lord.
Alla, Government of India, he was discharging his duty at Baba Atomic Research Center, Mysore. But one alle bartare. Anywhere he could have been posted, my lords. ID card ಇದೆ. ತಾವು ನೋಡ್ಬೋದು,
Yes,
page 17.
the father of the petitioner was an employee of the respondent number 1, working at the respondent number 2.
Yes, my lord.
Full stop. Therefore, this court, therefore, the petitioner was bound to approach the Central Administrative Tribunal challenging the impugned order. In that view of the matter, this petition is dismissed. However, liberty is reserved to the petitioner to challenge the impugned order before the tribunal. Office is directed to return the certified copy of the impugned order to the learned counsel for the petitioner Full stop. It is needless to mention that the time consumed in pursuing this petition shall be deducted while calculating the limitation applicable to a proceeding before the tribunal.
Grateful.
Yes.
Serial number 29, Vinayak B.
Vinayak B. Vishnu Bhatta.
Lord, petitioners are, my lord, guest lecturers working in Mysore University, my lord. They have completed service of, my lord, 10 years in the university.
How many of them?
My lord, the petitioners, my lord, 6 petitioners are there. But my lord, there are, my lord, maybe
All of them
80%.
have completed 10 years?
10 years, my lord.
All of them?
All of them, my lord. My lord, similar matters, my lord, maybe around 80 to 100% are already approached this honorable court. One of the writ petition was, my lord, allowed directing the university to frame a scheme. Then, my lord, the writ appeal is pending. In the writ appeal also, my lord, there is an interim order not to disturb their services.
AGS that accept notice for respondent board. University of Mysore,
Sungai appears. Rajendra, learned counsel Rajendra Kumar Sungai.
Abhishek case directed accept notice for respondent number 2.
Lord, the interim
Within
order.
exit of hearing, comma, the respondents are directed not to relieve the petitioners. And not to relieve the petitioners.
Please. Great.
22nd April.
List on date.
22nd April. Serial number 30.
22nd, my lord. Let it be on, my lord, 28th or 29th or after vacation. I have some inconvenience, my lord, in that week.
Yes, next number 30.
30.
My lord, the petitioners, my lord.
Appear for respondent, my lord. Sorry, my sorry.
Yes, what are the facts?
My lord, petitioners were, my lord, initially appointed in, my lord, Mysore labs. Then, my lord, absorbed, my lord, then deputed, my lord, in BWSSB. My lord, government took a policy, they had a policy decision, my lord, to absorb the services, my lord, who are working in the public sector undertakings. Annexure E, my lord, the BWSSB took a decision, page 55, to
Rangnath Joshi appear for the BWSSP.
Sorry, my lord, I have mentioned wrongly. I'm sorry. No, my lord, I am sorry, I mentioned the wrong. I was in the wrong. No, I don't appear in.
AGF, HCGP is directed to accept notice for respondent number 1. BWSSP jaridare. DL Sanjeev Obrena.
previous matter appear as previous matter. Lord, in the earlier, my lord, BL Sanjeev appeared, my lord, for BWSSB.
Mr. BL Sanjeev is directed to accept notice for the response 2 and 3. Yes.
Please.
Manish Kumar.
My lordship, I am for the petition, my lordship. Writ of mandamus, my lordship. Regarding pension, my lordship.
For
my lordship, she is the wife of the deceased Krishnamurthy, my lordship. She was working, he was retired from BSNL, my lordship, in 2020, my lordship. So he died on 13 to 2023, my lordship.
when did you
She
file
submitted
your
application. Annexure 3, my lordship, page number 18, my lordship. 21/9/2024, my lordship.
When? Yeah, DST is directed to accept notice for the respondents.
Date may be fixed, my
Immediately after vacation.
please, oblige, my lordship.
Very possible. The Rangnath Joyce.
Passed over matters.
Ready, my lord.
Passed over matters. Serial number 3. Serial number 3. Rangnath is Joyce.
Yes, Badrinath. Badri Vishal. Madam, this is a passover. We're taking up the passover matters itself. Let him
That's
argue.
a simple case. That's a simple case of a lecturer and is covered by decision of this honorable court affirmed by the apex court. The facts of the case are that the Lordship may kindly see the petitioner was appointed as a initially as a part-time lecturer, but later as a full-time lecturer. Kindly see page number 17. 1991, petitioner was appointed initially as a computer science temporary part-time lecturer. That was for a short time. Thereafter, it was renewed on 13/9/91, again appointed as a part-time lecturer in mathematics. Thereafter, in the year 1993, the formal interview was conducted as per annexure B1, calling about 6 candidates for full-time and two full-time and one-time part-time lecturer in Department of Mathematics. Okay, page number 20, interview was conducted. An interview cum demonstration lecture was conducted for post of 2 full-time and 1 part-time lecturer. In that, the names of the candidates are given in the order of merit. Petitioner is the first person full-time lecturer. Accordingly, annexure C, the order of appointment dated 20th July 93. Srimati Aparna TR is appointed temporary full-time lecturer in the Department of Mathematics in the college, consolidated salary of so-and-so. Then, my lord, since then, my lord, I have been continuously working without even full-time, all discharging full-time duties. Then, my lord, in the year 2002, I had filed an appeal before the authorities, my lord, and the appeal was not disposed of properly. And then the petitioner had approached this honorable court, and the honorable high court allowed the petition at page number 30, directing the appeal to be considered on merits regarding regularization. Page number 30, annexure A and B are quashed. Matter is remitted to first respondent to consider the appeal of the petitioner on its merits and to pass an appropriate within a period of 6 months. Then, my lord, your lordship may kindly see, thereafter, the lord, final order in the appeal came to be passed only in the year, that is annexure N, which is the subject matter of the present writ petition. Kindly come to annexure N, my lord. In fact, my lord, if you want, once again the matter was referred back, my lord. Second time that your lordship may kindly see page number 52, annexure K. My lord. In 2008, again, my lord, the order which was issued by the respondent was questioned, as it was not a properly speaking order. And then, my lord, this honorable court once again directed page number.
Mr. Joyce, what did you question before the authority?
Regularization, my lord. Regularization, my lord. Kindly see when page number 57, because I don't want to say earlier facts, page number 57, para 7. Petition is hereby allowed. Impugned order dated 11/7/2008, passed by first respondent in communication is third respondent is quashed. Matter is remanded to the first respondent to fresh disposal in accordance with law, keeping observation made above by providing an opportunity to the petitioner. Having regard to the length of time consumed in the country, the first time is hereby direct dispose of the appeal filed within 3 months. Then, my lord, the order now passed under the impugned appeal is annexure N. This is the subject matter of the present writ petition. Kindly see annexure N.
Page number?
161. 161.
161.
1?
Start from 161. 1. The appellant, page number 160. This is the department appeal pursuance of the orders of the High Court. Present case is up for hearing as per directions of the High Court, wherein relieving order of the college was challenged with a further direction to regularize the appellant service and other consequential benefits. Appellant was appointed initially as a part-time lecturer in computer in 1687, mathematics, and has worked up to 91, and in 93 as a part-time in the said subject. Thereafter, in 93, appellant was appointed full-time lecturer, mathematics by the principal of the college. Appellant has submitted the appellant. Then, my lord, these are all facts, my lord. Kindly come to the second para, my lord. because I had relied on judgment of one Manjula's case, my lord, para 2, appellant has claim for regularization of her services based on the orders of the Honorable Apex Court in the case of Secretary of Soma Devi and Honorable High Court in the case of Manjula versus State of Karnataka. Manjula is a lecturer in the same college who was working as, and her approached this Honorable Court and her case had been directed to be, therefore she had relied on that, my lord. Then, my lord, your lordship may kindly see page number 162. Para 3, any request for regulation of services has to be examined as per the yardstick laid down by the Apex Court and held that the steps should be taken to regularize service of such irregularly appointed who have worked for more than 10 years or more in duly sanctioned court but not under covers of order of the tribunal and should further ensure that regular recruitments are gone to fill those vacant posts in case of temporary letter. As per the law laid down by the Honorable Supreme Court, a person seeking regularization must be working for 10 years against sanctioned court without help of court order. In the instant case, kindly see, this is the very important. In the instant case, although the petitioner has discharged the duties of full-time lecturer, he has not been appointed against sanctioned post as she has not been selected by a duly constituted committee as envisaged under 81 and by following the procedure enumerated. Further, perusal of B12 to 13, it is clear that the sanctioned post of lecturer in maths became vacant in superannuation in 2001 and 2006. In view of the terms of so the government has issued an order reducing the grant. The 2001 order came to be subsequently changed and as per which all vacant posts of teaching and non-teaching staff were declared permanently unaided posts and the date of then, the posts of lecturer became vacant in 2001 and 6 have become unaided and on supervision of the incumbents, the posts vacated. So, then, petitioner has not worked against sanction for over 10 years. So, the two reasons that were given is that initial appointment in 83, it was through interview it was done. It was not according to cadre and recruitment rules. I mean, 10 years admittedly I have 10 years service, sanction post. For that, this matter was heard for some time before this Honorable Court earlier bench. Kindly take the order sheet on 9/10/2023, This Honorable Court clear after hearing some time and after hearing the management as also the government, kindly take the order sheet of 9/10/2023.
Yes, Mr. Josh.
My lord, it is the contention of the petitioner. Lordship got it, my lord?
Yes, I have got it. I got it. I got it.
My lord, it is the contention of the petitioner that she has been working as a part-time lecturer since 91 and full-time lecturer from 93. It is contended petitioner was working in a sanctioned court, but the process of selection was contrary to the government order. The appointment order which has been produced by the respondent institution indicate that petitioner was appointed in 1991 as a temporary part-time lecturer and same was subject to approval of the Deputy Director of Collegiate Education. Second order appointed on 13 and it also states that petitioner was appointed as temporary part-time lecturer and the same was subject to approval of the Director. Other appointment order stated 792 is also, it is however admitted that petitioner was working as a full-time lecturer since 1991. In the light of the above, the management is directed to file an affidavit as to the number of vacant posts that were available in 1991 and 93 in mathematics and lecturer who had been appointed working as either full-time or part-time lecturer and the period of time. The affidavit shall also state as to whether temporary made by Annex R2 approval of the Deputy Director of Education. Thereafter, they filed an affidavit. The affidavit was filed on 4/11/2023.
She has been regularized to the false.
Got the affidavit, madam.
Just a minute.
Affidavit ಅಲ್ಲಿ para 2. I state that the Honorable Court by order dated 9/10.
Mr. Joyce, please wait.
ಸರ್ ಅಲ್ಲೇ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ದು ಸರ್ ಅಲ್ಲೇ ಮಾಡೋಣ ಅವ್ರ ಎದುರಿಗೆ ಮಾಡೋಣ ಸರ್ ಬೆಟರ್ ಅದು ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಅಲ್ಲೇ ಮಾಡೋಣ
November. 4th November. Yes, I have it.
My lord, para 2.
Yes.
I state that this Honorable Court by order dated 9/10/23 had
Yes,
directed
Mr.
the
Joyce.
of the affidavit. As per
The
the
affidavit.
Honorable High Court, wide out 9/10/23 had directed the answering respondent to file an affidavit regarding the vacant posts available in the mathematics department from 91 to 93 and the lecturers who have been appointed working on full-time and part-time basis. During that period of time, further, this honorable court had directed to state whether temporary appointments of petitioner by answering the respondent produced as an A R1 to so and so, approval of the so and so.
Sir, it is
Then, my lord,
94. She has been reduced.
then your lordship may kindly see 91 to 92, total number of sanctioned posts 3, total number of full-time lecturers 4. In that, your lordship may kindly see. Just see, that is as on 91, 92, my lord. So far as mathematics is concerned,
Yes.
page number 3, 92 to 93, total number of sanctioned posts, my lord. Four, Premalata, Champa Kalakshama, Sujata D, V. Sarasavalli, and petitioner, my lord. Though it is stated as management, my lord, the petitioner has been working against the sanctioned post only, my lord. And therefore, we filed a reply to this affidavit, my lord. We have
Sir,
filed
the last person has been
reply
regular.
How
affidavit.
do you
We have
say
filed
she was working sanctioned? No, no.
2011,
Please come to page
2023.
3. Total number of sanctioned.
Four.
Total
Four,
number
ma'am.
of sanctioned post is 4. So there are already 4 persons working above you. Full-time, and all of them are ED.
One Srimati Sujata, my lord. She was not at all working at that time. For 3 years, she remained unnecessarily absent and went to foreign without permission of the department. Against that post, I was working. Management is trying to conceal that this, as if this person was working. In fact, my lord, that is why the connected writ petition, where this person was sought to be given pension, though she had not worked for those 3 years. That has,
You should come to the court otherwise.
yes, that is correct.
Please
my
come
lord.
to the court or you set
Today-
your internet in order.
My lord, that's why, my lord, one may request. Today I have some backache since 2 days. I am, because the matter was posted, my lord.
Why don't you
somehow
take rest if you have back?
because your lordship has
You're
imposed the
troubling
cost on
yourself,
the
you're troubling
respondent.
the court also.
Last occasion, last imposed the cost on the respondent. So I did not want to somehow, because I should not, it not be said that I have taken time, my lord. That is the reason I have, with great difficulty, I have come to ask.
Yes.
So, my lord,
Yes, please
now,
go on.
of course, that question is
No,
redundant
I asked
in
you
view
one
of the,
question.
yes.
Whether this Sujata has been removed from service. You said she was unauthorized
Not
absent for 3
removed, but
years.
she was not removed, my lord. But
Work, promotion, everything.
my lord, she was not removed, but she was not in working at that relevant point of time.
6
It was the
years.
petitioner who was serving the department. She was unnecessarily absent, my
Therefore,
lord.
you cannot say that you are working in a sanctioned post. You are working as
My lord,
on
that's apart,
temporary
my lord.
basis.
No, approved.
My lord,
That is
in
why
fact,
you're
the
taken on
reply
part-time.
now,
No.
my lord, in the government order itself, it is stated that she was working against a sanctioned post. Kindly come to the reply statement filed by the very same respondents, the state government, in the earlier writ petition filed by me, which I have produced as the reply filed before this honorable court, my lord. Kindly see the reply statement at page number 175, which is the reply filed by the state in the earlier writ petition, the 13,810 of 2008. Kindly see, my lord.
13,000?
WP 13,810 of 2008, annexure yes, page number 173.
Half salary we have paid.
$173 na?
Howದು. 173 it starts. Relevant page is para 6.
ಸರಿ ಇದು ಹೇಳ್ಬೇಕು.
Yes,
has been regular.
Page number para 6, 177. Assembly submitted that it appears that the third respondent by an order data annexure B dated temporarily appointed the petitioner as a full-time lecturer in mathematics on consolidated salary of so and so. She was continued as a full-time lecturer from that date. She contended that she had discharged the duty workload of 16 to 17 hours in a week and gave representation to the director of college education for regularization of her services on the third respondent college. The Joint Director Collegiate Education rejected the order. That is there. Then come to
Salary.
page number 181, para 10. Number 181, para 10.
Yes.
Admittedly, the petitioner has worked as a part-time lecturer from 91 to 92, 93, computer science, as well as lecturer in mathematics as a full-time lecturer. For regularization of service, the candidate must
Part-time.
They have paid salary.
Reading it wrong.
Reading it wrong. Sir, ಇಲ್ಲಿ ಬರ್ಬೇಕು.
para 12.
ಅಲ್ಲ ಇಲ್ಲಿ
para
ಬರ್ಬೇಕು.
12 madam.
Para 12.
ಅಲ್ಲ para 12 ಬನ್ನಿ sir, para 12.
Para 12.
It is humbly submitted. Third respondent institution showed the workload of mathematics clubbing the aided work and unaided work. If she bifurcates the aided workload and unaided work load, the 4 aided lecturers are working in the mathematics. They are taking care of the aided sections. Petitioner was discharging the functions of the unaided section. She has been paid 2 checks, one for discharging the function in the unaided and another check for discharging the function of part-time of aided section. Hence, it is clear that discharging the function of aided section as a part-time lecturer.
Sir, the last person has been regularized to the government.
So, my lord, this question of sanction post becomes redundant in view of the latest judgment, my lord, list of authorities which I have produced. Kindly see, my lord, let us not come to that question at all, because now latest judgment of the division bench of this honorable court, as also the Supreme Court, following Supreme Court, kindly come to the judgment in first, my lord. Page number 52. I have produced a list of authorities, my lord, on 22/3/2025. List of authorities produced on 22/3/25. In that judgment, first single judge judgment, I will point out, my lord, page number 52. Come to para 3. There also question of sanction post work was raised by the respondent. Then how the court has considered para 3 onwards. Having heard the counsel for the parties and having perused the petition paper, this court grants relief to petitioner following reasons. Assertion of the petitioner they have been in the casual employment of the respondent since more than a quarter century is admitted, and the impugned order itself. There is no complaint against the petitioner about the working being done by them. In fact, the case of petitioner is covered by para 44 of the Umadevi. Many such casual employees having been regularized in service is a fact which the court takes judicial notice of. Thus, the ratio in Umadevi does not come in the way of regularizing service of the petitioner. Second contention of the learned government advocate that the petitioners have been engaged is true, but it is not against sanction post, is not legally tenable. Settled position being that sanction pales into significance once an employee is made to work for a very long period, like the petitioners here in continuously. Even otherwise, the employees do not have any role in the matter of post being sanctioned. Once it is shown that the petitioners have been working without the aid of the court order stay uninterruptedly, then relief cannot be denied to them and knows the decision in Nihal Singh versus State of Punjab. The pay case also finds support from the judgment dated so in Krishna Gramin Bank and ML cases. Service of the petitioner were dispensed from 1991, and the Labour Court has judgment award dated reinstatement and copy thereof. Petitioners raised the complaint refusal of minimum wages, and that is regarding them. Then, my lord, come to the page number 88, para E. Para E. Ordinarily, a writ court does not itself direct regularization of service of the employees. Writ courts being a direction being issued to the concerned for regularization. However, case of the petitioner is in exception of compels this court to be deviate from the
where are reading?
Page 88
number?
of the page, internal page number 7 of this judgment, very judgment.
Page 88.
Ink page 88, page 7 of the internal page of the judgment. Para E. This very judgment which I was reading.
88 is some judgment passed in division bench.
58.
Sir, 58. That is 58. I am
Page
58. 58. 58. Ordinarily, a writ court does not itself direct the regulation of service of the employees. The right course being direction being issued to concerned authorities to consider the claim of regulation. However, case of petitioner is an exception that compels this court to deviate from the traditional approach in as much as the petitioner were before the court twice. As already mentioned above, they were made to fight legal battles before the labor court and before authority, even for payment of minimum wages of the court successfully. The text of the impugned order, the contention of statement, objection, and the submission warrant this court to issue a mandamus response to regular services. In the circumstances, these writ petitions succeeds and the writ issues quashing the impugned order and the writ of mandamus issued to petitioners regularization of petitioner services with retrospective from the date they completed 10 years of service. This matter was taken up appeal before the division bench in next page, my lord. Next page.
Yes.
The division bench also, my lord, affirmed the order of the single judge, my lord.
Yes.
And in view of the latest judgment of the apex court in Jaggo's case, which once again, my lord, latest one more judgment, page number 14 of the same paper book, my lord. Jaggo's case, my lord, your lordship is aware. Following this judgment, the judgment has been rendered. And so far as the other case and where Manjula, who was similarly situated like the petitioner, my lord, kindly see, my lord, there also, the case of Manjula, which I am referring to, is relating to the same college. She was also working against
approved post, sanction post.
She was also not working against sanction post. In fact, the order itself states so. Come to page number.
Writ petition.
Page number.
Page 22.
In the writ petition, my lord, page number 75 onwards. Page Manjula's case, page number 75 on the writ petition paper, original writ petition papers.
Yes.
The petitioner has been working as a part-time lecturer from 1994, my lord, that case. It is petitioner case that she was allotted full-time work.
This is from Bharat Education Society.
Bharat Education. That is also aided institution. And therefore, before this court seeking suitable direction of the response to
You said this is BM Education Trust.
Not BMS, Bharat
Education.
My lord, and therefore, before this court seeking suitable direction to respond to absorption of full-time lecturer in economics in available vacancy, as she has been working for more than 10 years with all consequence. It is the petitioner case that she had possessed the post-graduation in economics from Mysore University and that she has appointed as a part-time lecturer per month and she has been working continuously. Her salary has been improved from 1,200 in 98. And it is the case of petitioner department. The first response consists of head of the department, which is occupied by so-and-so and aided by state government as a sanctioned post. Since there was heavy workload in economics, petitioner was allotted excess hours of 16 hours. Petitioner continuous request for absorption in the workload over has not been added to. It is the background that petition is filed. Vasant Kumar, the counsel for petitioner, would submit that petitioner has discharged full-time duties with the respondent institution for over 12 years. Since the immediate senior of the petitioner has now been promoted as principal, there is a sanction. What she contended was that now there is a sanctioned post. Melody, as on the date when she was appointed, there was no sanctioned post. But as on the date when the petition was disposed of, subsequently a person has retired, that principal, and thereafter the sanctioned post. Then the court took into the consideration there is a sanctioned post which is vacant, and petitioner would be accommodated in such a vacant post as the petitioner had discharged his duties as such as for well over 12 years, and there is no impediment in this regard. He would further submit that petitioner case would clearly fall within the exception called out in Secretary versus so-and-so, and that it would serve the interest of justice that petitioner has been discharging duties as a full-time lecturer, though technically she was appointed as a part-time lecturer. And since there is a sanctioned post in which she has been accommodated, it is appropriate for this court issue direction to respond. Per contra, counsel for respondent would contend that Jagadish, who was head of the department, has been promoted as principal. Post is not duly sanctioned till such time there is no sanctioned post. It cannot be said that the petition can be accommodated in the post which is held by R. Jagadish, and therefore would submit that the petitioner has not made out a case, and it is also not correct to contend petitioner case will fall within the frame of Uma Devi and accommodate only upon sanction of the post of post principal which has not come to pass, a pass therefore. On these rival contents, rightly submitted, Sri Vasant Kumar in his reply, formality of sanctioning post of principal remains to be done. It cannot come in the way of petitioner being accommodated and sanctioned post which fell vacant on account of Sri Jagadish, who has been promoted as principal and whose promotion has been approved by the government. It is seen that as per the order that to 2006, may not kindly see, she was appointed in 91. The post 2006 post of Jagdish became vacant and duly approved by the government, and it remains only formality of sanction of the post of, and if it remains to be done, it is for state to take abrupt. In the meanwhile, it would be unjust to deny the request of the petitioner who has been continuously discharging her service for over a period of 12 years, though technically she has been appointed as part-time lecturer. In this regard, there is no dispute by the respondent. It is only the technicality involved in the feasibility of accommodating the response makes submissions, and in opinion, it would not be correct to say the petitioner case would not fall within the purview of Uma Devi's case. Accordingly, petition is allowed. My lord, this matter was taken up in appeal. Next page 82.
Correct. The facts ಮೇಲೆ ಅದು ಮಾಡಿದ order ಮಾಡಿದ್ದಾರೆ.
What I am saying is, in that case also sanctioned, because much is made out that as on the date when the petitioner was appointed, sanction post was not there.
There's a vacancy on account of a promotion of a person as a principal.
But in 2006, ನನ್ನ ಕೇಸಲ್ಲಿ appoint ಬರುತ್ತೆ. In the government order which is challenged, annexure N itself, your lordship. Annexure N itself, your lordship may kindly see. Regarding post, kindly come to post, my lord. Page number 162, my lord. In fact, I read it over. Now I will read, because after this order, now it has become relevant. Kindly see page number 162. While the government rejects my claim for regularization, my lord. Kindly see.
You asked the lady to keep quiet. She has been interfering.
Yes. I told her. My lord, now come to my lord, the last but about 6, after annexure B12 and B13, it is clear that the sanction post of lecturer in maths became vacant on account of superannuation on 4/5/2001 and again on 2006. In the case of the Manjula, yes, the post became vacant in 2006. In my case, a post had become vacant in 2001 itself, and again another post in 2006. Therefore, and that lady was appointed in 94, whereas I was appointed initially in 91 and again in 93, mathematics full-time lecturer. She was a part-time. I am a full-time, discharging full-time duties. Therefore, my lord, they having regard to this factual aspect that the vacancy arose.
Did you continue to work till you filed the writ petition?
Till the impugned order was passed, I was working. In fact, after challenging this annexed order, that is as on 2012, my lord, I was working from 93 up to 2012. I was working. I sought for stay of this order. Unfortunately, even after issue of notice on 2 occasions, I pressed for stay order. Stay order was not given.
What is there to show that you were working till the impugned order was passed?
I was relieved after that. Kindly see page number 164, my lord. That order itself says now I should be relieved anta helta. I have been relieved on annexure O, page number 165. Annexure A, O, my lord, page number 1, dated 19/8/2013. Srimati T.R. Aparna, part-time lecturer in Department of Mathematics, so and so, is relieved of her duties on 16/8/2012 afternoon wide order, so and so. Aparna challenged the order effort paper by the Honorable High Court, and the Honorable High Court in judgment disposed of the writ petition, remitting the Principal Secretary of the Government of ISO to confirm.
Let the other side respond.
Yeah.
1991, admittedly, my lords, she got into the college as a part-time lecturer, appointed as a part-time lecturer. She did not wait, my lords, for a long period as what is mentioned. She did not wait. In 96 itself, my lords, the first writ petition came to be filed in WP number 7532 of 96, where she sought for regularization. 7532 of 1996.
Was there an interim order in that case?
Ali, my lords, she worked. After that, in this petition, my lords, it was disposed of with liberty for her to approach the government for the purpose of seeking regularization. Thereafter, she, my lords, approached the government Government rejected her request in 2001.
Yes.
The contention of the management, my lords, only 4 points. This, my lords, is not against any notified sanction post. She never worked against, because notified sanction post, we call for advertisement. It is in that manner that an appointment is being made. In this case, no such appointment has been made through any notified sanction post. And your lordships also saw the affidavit filed by the institution. There was no sanction post vacancy during those that period. Then, my lords, even in Uma Devi's case, my lords, it categorically says that they should have worked for 10 years or more. That in 96 only she is approached the court within working for 4.5 years.
Correct, but did she work from the year 1991 till the year 2013?
She is. That I cannot. But it is on the basis of interim order.
That's okay.
In fact, the judgment quoted by.
ಅದಕ್ಕೆ ಕೇಳಿದ interim order ಯಾವ್ದ್ರಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂತ 2001 ನಲ್ಲಿ it was
ಎಲ್ಲ writ petition ನಲ್ಲೂ interim order ಇತ್ತು for the purpose of
My lord, in WP number of 96 which my learned friend is referring, there was no interim order, my lord. I'm sorry, he is referring judgment of 26/6/97 when she approached
this 2013 I've relieved her, so therefore my lords there is no
no if she has worked pursuant to interim orders granted by the court,
please,
that may have to be what you call discounted.
That is what the judgment referred to by my friend, my lords, at page 55, in page 55 in the division bench judgment, single judge judgment at page 52 it starts. It categorically says that even otherwise the petitioners have been working without the aid of court orders. So here it was with the aid of court orders that she functioned.
Can you
let him show?
The authorities say that in 2001 when the she was working without any interim orders.
I'll right.
No, because in 2001 and 2006 there was a vacancy.
There was no vacancy, my lord. I have filed an affidavit.
That is the.
I have filed an affidavit.
Please come to page 162.
162.
There's a reference to certain 2 vacancies which arose after 2 sanction posts, I think.
That is affidavit where every year I have extracted, my lords, what are the vacancies which were available.
This is some order annexure N. Page 162.
How? This is a statement of objections filed by the.
No, this is the order.
This is the government impugned order presently passed by after hearing.
How?
I don't think you would have taken this petitioner. You would have recruited this petitioner on part-time basis, taking into account the fact that she has got all the qualification.
Yes.
She is allowed to work from 1991 till 2013. There are 2 posts which became vacant on account of superannuation. So therefore, this lady could have been
considered at that time.
You're correct, but then because you have been contesting her claim.
Ultimately, regularization is.
Court time is being looted and you simply keep quiet. Half an hour, 40 minutes.
Salaries also, my lords, has been paid only by the management.
So you're not averse to regularization. As an institution, you're not averse.
I have no clue, my lords. Ultimately,
Yes.
I may not have.
Tomorrow, will you argue?
Tomorrow I have got in.
Meanwhile, I'll also check, my lords, between that period.
Our argument.
Tomorrow day after I have got. Monday, next Monday.
When I expressed my opinion, you should be happy to have this, that I had this matter tomorrow.
But now he have got some inconvenience tomorrow. Anyway, I don't want to
ಅವ್ರು argue ಮಾಡ್ಲಿ.
ಆಯ್ತು.
For tomorrow, further arguments tomorrow.
Serial number 7, AJ Srinivasa.
For the petition on this matter, my lord.
Sriramba?
7, my lord.
Yes, Mr. Yar, other side. DA Anil Lakshmi Narayan, Ramachandran,
CGC
Road
for
Ward.
R2. K. Ramachandran for R3.
Yes, please go on, madam.
Please, my lord. My lord, the matter, the petitioners herein, my lord, are employed in urban family welfare centers, which are run under the ambit of the government of India, my lord. The process, my lord, comes to be that these urban family welfare centers are required for the lower income sections, my lord. And therefore, they are provided by the government. The process, the government of Karnataka to each of these centers. The salary is on, there are in this center, my lord, the petitioners are discriminated and not paid equal amounts. Initially, my lord, they are paid equal amounts, but as time passes, my lord, the amount being paid is not increased on par. If my lordship can peruse Annexure A to the writ petition, this is a analysis of what was due, what was drawn, and what the difference was. Initially, my lordship might see this was broadly in accordance with the pay scales. But if my lordship can turn to the last page of annexure at page number 27, page number 28, my lord, the payment received by workers in the other centers was around 45,800, and these workers were only receiving 19,515. They issue a representation, my lord.
Please wait. You're in a hurry.
Sorry, my lord.
Turning the pages, you're already going to the next point.
I apologize, my lord. Yeah. Page number 28, my lord. This is in October 2015. The bottom of the page. My lord might see that the first set of columns pertain to the due amount. And the total due amount at that time was 45,800, which other workers were receiving in other centers. Whereas over here, my lord, the total amount being received was 19,550. Paid at that time, my lord, was 34,000. Half, my lord, is being received by these workers. Then, my lord, a representation comes to be issued by them. The state government gives a letter at respondent number 3, which is the institution, which is a show cause notice. Translated copy is available at page 35, my lord.
Yes.
Seeking that the respondent number 3 replied to the said representation. Unfortunately, my lord, no decision is taken. That is communicated in annexure number D at page number 30. Your letter dated 6th May 2016 was discussed at the administration level and also sent for legal advice. Hence, it took some time to submit our reply. We regret for the same. We have placed your letter for accepting government scale before our working committee, and the decision is yet to be taken. We will intimate the outcome of the decision taken by the working committee or hospital board of the management. Till then, we request you to kindly accept the budget for the year 2016 to 17 as per our hospital salary scale, and also to allow us to follow the procedures for getting grant in aid. So at this stage, my lord, the petitioners approached this court, and in view of an interim order
as directed by this court, a decision comes to be taken. If my lordship can see the affidavit of the respondent number, if my lordship can take the affidavit of the respondent number 3 dated 17th July 2019, my lord.
ಎಲ್ಲಿದೆ? ನೋಡಿ ಎಲ್ಲಿದೆ? 17 July.
Please, my lord.
July ಇದೆಯಾ? It was filed in the court.
I am only giving the copy of the affidavit as it is.
No, it's not here.
I may be permitted to hand it over, my lord. I may be permitted to hand it over, my lord.
ಇದೆಯಾ ನೋಡಿ ಇದು?
So, my lord, in the said affidavit,
ಅದು IA early hearing. So according to the affidavit filed by respondent number 3, this money was reimbursed by the state government.
please, my lord, in fact, the entire amount actually comes from Government of India, who's the respondent number 2 herein. That amount comes to be dispersed by the central government to the state government. And the state government pays the entire salaries of these workers. So there's no financial implication per se to the respondent number 3 at all.
Who appears? Yes, for the institution, respondent number 3.
K. Ramachandran.
Mr. K. Ramachandran. Where is Mr. K. Ramachandran? Last time he was here.
Last time a colleague of his had appeared, I believe.
ನೀವೇನು ಕೊಟ್ಟಿದ್ದೀರಾ, ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಿ?
My lord, what happens, my lord, this is the central and state project, my lord.
Yes.
Central government, my lord, the NGO, whatever respondent number 3, my lord, raises the funds to the state government. After verification, state releases fund to this such institutions. Thereafter, central will refund by the amount demanded by the state government. Here, what happens, my lord, the third respondent itself, they are to grant the respondent number 3. But if they taken up the decision, well, they have to approach this state government, my lord.
Yes. Respondent number 3 does not make a request.
My
And
lord,
these people are made to work for half the salary that others are being getting.
My lord, since, my lord, the state government has to look out all those things, my lord. You know, state, my lordship, that is state government, my lord, thereafter they will.
That is okay. So far as you are concerned, you are willing to pay.
Please,
Yes.
if the state makes the request.
Pass over.
Obliged.
Please inform Mr. Ram. Time ಕೊಡಲ್ರಿ. ಯಾವ ಕೇಸಲ್ಲಿ ನೀವು ರೆಡಿಯಾಗಿ ಬರೋದಿಲ್ಲ. Correct, let the advocate for respondent number 3 make a submission.
Serial number 8, Vijay Kumar.
Vijay Kumar.
Serial number 8, I appear for the respondents, my lords.
Lords, may I
Yes.
kindly have the matter at 2:30, my lords. Arguing counsel is on his legs, my lords. 2:30.
ಇದೇನು irritation ಇದು. You get it passed over in the morning, now you say 2:30. Why don't you argue, mister?
Apologies, my lords. Arguing counsel, my lords, is on his legs, my lords. 2:30,
No,
my lords.
apology, you keep your apology to yourself. You were there when the matter was passed over, now you say 2:30.
Yes, my lords. My
The
apologies.
list is almost 80 matters are listed.
Yes, my lords.
Grant counsel for the petitioner, respondent number 1 to 4, again seeks time.
My lords, Passover, my lords.
Again seeks time. Passover, I don't think in the afternoon session, I don't think we can take it up. The list is long. Yes, next, list after vacation.
Serial number 11, Likhi Tarpi.
Likhi Tarpi.
Like this is a case your lordship is followed. Let the writ appeal 100387. I have already filed along with them.
Memo dated 25/3.
More dated?
25/3/25.
Lord, there are two memos filed by me on the last date of occasion. Lord, one is the commercial tax department where 10 years.
Have that.
Yes. Then SLP, then implementation order. This
what
is
are the
an
facts
order,
of-
my lord, rendered on 4th December 2000.
Okay, what are the facts of this case?
Lord, I am working, my lord, in a C group
Hmm.
in Kakun market, my lord, Channapatna.
Hmm.
My lord, the totally 33 years of service I have put in.
Yes.
1/7/1984, my lord, is the appointment. Totally 30 years. Now, my lord, my learned friend has filed objection statement relying on the judgment where a person was appointed in a project sought for regularization. The Supreme Court said no. I also concede, my lord. This is a case where persons who are appointed, my lord, after 1/7/84, not covered by the Dharwad scheme. And the very similar question has been argued before this, the view that the cutoff date cannot be the basis to deny the regularization if an employee put in 10 years of service. And that judgment, my lord, was confirmed by the apex court.
Yes.
The two judgments, my lord, that is commercial tax department, may I take your lordship's, my lord, the commercial tax department, writ appeal number 8700, the memo dated 19/3. 19/3. Writ petition number 8700 of 2021.
All these petitions are from the Sericulture Department?
Yes.
All of them?
Yes. In fact, elaborately, my lord Justice Shyam Prasad Jay, my lord, which we have put it as an annexed judgment. All these arguments have been advanced by the learned additional advocate general.
Yes.
And it has been considered on the touchstones of Article 14. May I take your lordship's, my lord, in the 8700 of 2021.
Yes.
That internal page 26, my lords.
Yes.
Para 18.4. We have called for the data in the instant case to ensure as to how many employees were working on a contract basis or ad hoc basis or daily wage basis in different state department. We can take judicial notice. This court has emphasized that incumbent should be appointed on a regular basis as per the rules. But new device of making appointment on a contract basis has been adopted. Employment is offered on daily wage basis, etc. in exploitative forms. This intent of the decision was that employment process should be by a fair means and not by backdoor entry. Has been ignored and conveniently overlooked by the various state government authorities. We regretfully make the true spirit and a not service without payment of the salary for which they are entitled on the basis of Article 1416, read with Article 34(1) of the Constitution of India, as if they have no constitutional protection, as envisaged in T.S. Nakara versus Union of India, from cradle to grave. In heydays of life, they are serving on exploitative terms with no guarantee of livelihood instituted. There being no provision for pension, retirement benefits, etc., there is a clear contravention of constitutional provisions and aspirations of downtrodden class. They do not have equal rights, and to make them equal, they require protection and cannot.
These are all settled position.
Yes.
We need not again reinvent the wheel. Now, in all these cases, they put in more than 10 years.
Yes.
Have you made a statement to that effect?
Yes, my lord.
Yes.
The petitioners
Not more than 30 years.
under a nominal muster role, seasonally they were engaged.
What do you mean by season?
Means they say agricultural department, your lordship, is in respect of that. The
What do you mean by seasonal? They don't work in the farms.
It's a cocoon market.
ಅದ ರೇಷ್ಮೆ ಬೆಳೆಯುವಾಗ ಮಾತ್ರ ಅವ್ರನ್ನ ಎಂಗೇಜ್ ಮಾಡ್ತಿದ್ವಿ, ಮತ್ತೆ ಆಮೇಲೆ ಎಂಗೇಜ್ ಮಾಡ್ತಿದ್ರಲಿಲ್ಲ.
ಬೆಳೆಯುವಾಗ these people don't work in the farm.
Yes, they work in the farm. That is our contention.
Yes.
And lordship, and ರೆಗ್ಯುಲರ್ ಆಗಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡೇ ಇಲ್ಲ. And there was no vacant post also for that. He had sought the services.
How did you pay them salary? For all these years, how did you pay them salary? Number one, in their
Daily wages
absence, no, in their absence, who would have been working? Who have been performing the work of these people? In their absence, who was expected to do the work? ಇವ್ರು ಅಲ್ದಿದ್ರೆ ಬೇರೆಯವ್ರ ಹತ್ರ ಮಾಡಿಸ್ಬೇಕು ಕೆಲಸ. Yes, correct. No, these people were according, correct?
Yes. Appointing authority has not appointed them.
Why did you pay the salary? Number one. How did you allow these seasonal employees to work for more than 30 years?
Intermittent, it is not continuous. It is not continuous. Whenever that was required, they were engaged.
Yes.
That is
what are the material that you have produced to show that they were all seasonal employees?
Please. Kindly,
I think we should start regularizing these people from the date of their appointment. We are doing a mistake from the date of regularization.
Lordship, earlier they had already made one round of litigation. Para 5 of my objections may be
That is right. But what is there to show that there are That is a problem.
Please, Your Lordship.
The government doesn't seems to stop this temporary arrangement, contractual arrangement, daily wages. You don't seem to stop. You continue to do it, thinking that the payment of salary will be from the date of regularization. From the date of appointment ಅಂತ ಕೊಟ್ಟರೆ ಅವಾಗಲಿಂದ I think ನಿಮಗೆ ಬುದ್ಧಿ ಬರೋದು.
Lordship, another thing, Your Lordship. If he was appointed, he claims that 17 after 1784. Nothing prevented him to approach for regularization at the earliest point of time. If he was regularly appointed.
According to you, if he can't get regularization now, he couldn't have got it then. So please point out what is there to show that they are all seasonal employees. ಏನಿದೆ?
Let service certificate, I'll read two lines.
Let him.
If Lordship, if 2 days accommodation is given, I'll produce the muster rolls of the employees concerned. Some on batch ಇದೆ ಅದು.
ಗೇಂದ ಇದೆ ಆಗ್ತಿದೆಪ್ಪ.
Because in my.
It's already 1 o'clock, Mr. AGA. It's already 1 o'clock. And from morning, everybody is doing this.
I'm sorry.
Half an hour tomorrow, day after tomorrow. What is this?
This with regard to the muster roll.
No, this kind of defense, Your Lordship may accommodate my learned friend, but ultimately, if my learned friend defense turns out to be an incorrect, my lord, I may plead before Your Lordship,
Yes.
from the date of joining, the state
Who
of.
will take the responsibility? If it is found that they are not seasonal employees, who will take the responsibility? Commissioner?
Please, Lord, the respondent.
After hearing the learned senior counsel for the petitioners, the learned AGA submitted that all the petitioners employees who work intermittently and not on regular basis in the cocoon market as claimed. Full stop. He contends that the respondents have maintained a muster roll of all the
Nominal muster roll.
Nominal muster. He seeks 2 days accommodation to place the nominal muster roll. Hence, list day after tomorrow. It is made clear that if the names of the petitioners are not found in the nominal muster roll, the respondents shall be nominal muster roll, the commissioner of sericulture shall be solely responsible for all the costs and consequences. Yes. List day after tomorrow.
Serial number 22. Serial number 22, Kavita M, petitioner, party in person.
Will this at least go on or should I adjourn it? Are you ready?
Yes, Your Lordship.
Are you ready? Adjournment ಕೇಳಿ ನಾನು ಕಾಸ್ಟ್ ಹಾಕ್ಬಿಡ್ತೀನಿ ಈಗಲೇ ಹೇಳಿದ್ದೀನಿ. If you ask for an adjournment, I am going to impose cost on whoever asks for adjournment. Aneksha? So what are the facts of this case? A case ಏನು ಅಂತ ಅವ್ರು ಹೇಳಿ ತಲ್ರಿ. ಉಪನಿರ್ದೇಶಕರು ಶಾಲಾ ಶಿಕ್ಷಣ ಇಲಾಖೆ. ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಇದಾರಲ್ಲ. Correct. This order is passed by the deputy director attached to the office of the director. It doesn't matter. Yes.
Lord, myself, I appointed as an assistant mistress by the state government on January 2004, my lord. 21 years agide, my lord, nandu approval agi. These are my approval
yes.
orders, my lord. So respondent 1, 2 and 3, my lord, they are my authorities. 2 years in the nanu avarna onde request ಮಾಡ್ತಿದ್ದೀನಿ, my lord, based on the section 145 of the Karnataka Education Act 1983 dated in a composite private aided
ಏನ್
pre-university.
ಕೇಳ್ತೀರಿ ಪೇಜ್ 12 of what? ಅದೇ ತಗೊಳ್ಳಿದೆ ನೀವು ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕು.
ಅವ್ರ ಹತ್ರ ಇದೆ ಮೇಡಮ್.
ಕಾಪಿ ಕೊಡ್ಬೇಕಮ್ಮ, ನೀ ಕೋರ್ಟ್ಗೆ ಏನೋ ಕೊಟ್ರಿ ನೀವು ಕೊಡ್ಬೇಕು ಅವ್ರಿಗೆ ಕಾಪಿ. ಅವ್ರ ಹೆಂಗ್ ರೆಫರ್ ಮಾಡ್ತಾರೆ? ಪೇಜ್ 12. ಹೇಳಿ.
In a composite private aided pre-university college, 50% of the total post of the lecturer shall be filled by promotion from the cadre of secondary school assistant if on the date of arising of vacancy, a secondary school assistant is eligible for promotion in accordance with sub-rule 2. A secondary school assistant working in a composite private aided pre-university college shall be eligible for promotion to the post of a lecturer if the secondary school assistant possesses a post-graduation degree in the subject in which he teaches in the high school. ನಾನು ಆಲ್ರೆಡಿ MSc ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ಮೈಲಾಡ್ ಸೇಮ್ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದೀನಿ. ಅದೇ ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಅಲ್ಲೇ ಪ್ರಮೋಷನ್ ಆಗ್ಬೇಕು ಮೈಲಾಡ್. ಇದು ಇರ್ತಕ್ಕಂತ ವೇಕೆನ್ಸಿ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ ಮೈಲಾಡ್. 50% ಆಫ್ ದ ಪ್ರಮೋಷನ್ ವೇಕೆನ್ಸಿ ಫಿಲ್ ಮಾಡಿಲ್ಲ ಮೈಲಾಡ್. ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ವೇಕೆನ್ಸಿ ವಿಲ್ ಕಮ್ ಅಂಡರ್ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ ಮೈಲಾಡ್. ಸೊ 2 years ಇಂದ ನಾನು ಅಥಾರಿಟಿನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ನನಗೆ ಪ್ರಮೋಷನ್ ಬೇಸ್ಡ್ ಆನ್ ದ ರೂಲ್ ಐ ಆಮ್ ಎಲಿಜಿಬಲ್ ಫಾರ್ ದ vacancy 1/6/2023 my lord.
1/6
vacancy arise my lord. Before 6 months ಇಂದ ನಾನು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಥಾರಿಟಿನ ಕನ್ಸಲ್ಟ್ ಮಾಡಿದ್ದೀನಿ. ಅವರ ಡ್ಯೂಟೇಷನ್ ನ ರಿಸೀವ್ ಮಾಡಿರ್ತಾರೆ my lord. ಸೊ ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ 9/2/2024 ಅಲ್ಲಿ ಗವರ್ನಮೆಂಟ್ ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡುತ್ತೆ ಇದನ್ನ ಟ್ರಾನ್ಸ್ಫರ್ ಪೋಸ್ಟ್ ಗೆ. ಬಟ್ ದಿಸ್ ಇಸ್ ನಾಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ವೇಕೆನ್ಸಿ ಮೈ ಲಾರ್ಡ್, ದಿಸ್ ಇಸ್ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ. ಇದು ಪ್ರಮೋಷನ್ ಮಾಡೋದು ವೇಕೆನ್ಸಿಯಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ತರ್ತಾರೆ.
ಯಾರು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ದಾರೆ? ರೆಸ್ಪಾಂಡೆಂಟ್ 4 ಜಾನ್ ಪೀಟರ್
ರೆಸ್ಪಾಂಡೆಂಟ್ 1 ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ಮೈ ಲಾರ್ಡ್. 4 ನ
ಅಷ್ಟೇ ಕೇಸ್ ನಿಮ್ದು
ಮೈ ಲಾರ್ಡ್?
ಇಸ್ ದಟ್ ಆಲ್? ಅಷ್ಟೇನಾ ಕೇಸ್ ನಿಮ್ದು?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಎಸ್.
Now, Your Lordship, I'm appearing on behalf of respondent number 4. Now, Your Lordship, my case is that I have been appointed as a lecturer in the year 1990, and I was working in St. Aloysius College where I was appointed.
Yes.
For 33 years, I was working there. Now, I have completed 35 years of my service. Now, in the St. Aloysius Pre-University College, since the management was unable to maintain the minimum strength of students, I, along with 2 other lecturers, had to be transferred since we were treated as surplus employees. Now, Your Lordship, the respondent number 1 and the director have approached all the aided pre-university colleges and sought for a vacancy list where I, along with the other 2 lecturers, could be accommodated. Now, the respondent number 2 BEL management had given the director and the deputy director a list of vacancies and said that I could be accommodated there. Thereafter, pursuant to the list which was given by the respondent number 2 management, I was appointed by the director first, and it was approved by the deputy director. And now I have already joined for duty.
But what should happen to those teachers who are working in BL college? What is the promotion avenue for them?
No, Your Lordship, what the pet followed. Yes. Now, the respondent number 2 is the appointing authority and the director, not the respondent number 1. She has not made the director a party to this petition. Yes. Now, the director is the approving authority. Now, her representation was kept pending for in fact. Hence, Your Lordship, my contention is that the petitioner does not have a locus standi because she is a high school teacher. Now, only the parties of the same cadre can challenge. Now, I am a lecturer who has been working as a lecturer. Now, she
cannot. But what about the promotional avenue for that lady, for this lady?
No, Your Lordship, only when it was vacant, she could have approached again, if it was not considered, she could have filed a writ petition as well
Yes.
to consider it. Now that I have been transferred, now I have nowhere else to go, Your Lordship, because as per the rules, 20 hours of teaching I have to do in a month. Now only BEL University at the moment has the vacancy.
Yes.
Now I cannot be accommodated anywhere else. So if she was promoted, then I would be terminated from my service.
Correct, but then what about the growth in the organization? She joined that institution thinking that she will get promotional avenue. Now somebody else comes and sits into this institution.
My lords, I represent respondent number 2 and 3. My contention is she is eligible for promotion and she is entitled for it. The reason why we didn't consider is because she gave a representation in middle of the academic year. So it was kept in abeyance. So because of that, and because if we got her transferred in middle of the academic year, it would have affected the students' life in that matter to completing the syllabus and everything. So by the time the academic year was over, someone else was appointed in that place.
Yes.
Now, Your Lordship, when I was being appointed, I mean, in
The government, you please take a call. Both. Para 9? Yes. Correct, but how can she be held responsible is what I am asking you. ಆಯ್ತು ಅವ್ರು ಮಾಡಲಿಲ್ಲ. How can she be held responsible? Yes, correct. She is only an individual. How can she move the management to compel her to promotion? The management has to do it. Management has to send a letter to the government saying that there's a post vacant. You please permit us to appoint or promote. The management does not do it. They sit idle. So the government sends some person to occupy that promotional post. Then where should she go? She will be. Consider Sumne will not increase the number of litigations. Either yes or no. Whether she should get a promotion or not. We'll close it. Pade barta irodu. We want to stop that. ಇಲ್ಲ ಬೇರೆ ಎಲ್ಲಾದ್ರೂ ಇದೆಯಾ? ಬೇರೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅವರು ಆಟೋಮೆಟಿಕ್ ಆಗಿ ಇವ್ರನ್ನ ಪ್ರಮೋಷನ್ ಮಾಡಿದ್ರೆ ವೈ ವುಡ್ ಶಿ ರೈವಲ್ ಅಗೇನ್ಸ್ಟ್ ದ ಮ್ಯಾನೇಜ್ಮೆಂಟ್? ಯಾಕೆ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ? ಕರೆಕ್ಟ್. ಸೊ ದೇರ್ ಫಾರ್ ಆಯ್ತು, ಬೇರೆ ಕಡೆ ಎಲ್ಲಿದೆ ಪೋಸ್ಟ್ ಹೇಳ್ಬೇಕಲ್ವಾ? ಎಲ್ಲೋ ಬೇರೆ ಎಲ್ಲೋ ಇದೆ ಅಂತಂದ್ರಲ್ಲ.
My lord, she can only be promoted to the same management.
ಬೇರೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ದೇ ವಿಲ್ ಸೇ ನಮ್ಮಲ್ಲಿ ಇದ್ದಾರೆ ಜನ ಇದ್ದಾರೆ ಅಂತ.
My lord.
It is okay.
My lord. My lord. My lord, ಇದು ಪ್ಯೂರ್ಲಿ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ ಮೈ ಲಾರ್ಡ್.
ಎಲ್ಲಿದೆ?
ಈಗ ರೂಲ್ ನಂಬರ್ 18(1) ಅಲ್ಲಿ ಇದೆ ಅಲ್ವಾ ಮೈ ಲಾರ್ಡ್? ದಿಸ್ ಇಸ್ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ ಮೈ ಲಾರ್ಡ್. 18(1).
Yes.
In a composite private aided pre-university college, 50% of the total post of the lecturer shall be filled by the promotion. ಇದನ್ನ ಮಾಡ್ಬೇಕಾಗಿರೋದು ಅಥಾರಿಟೀಸ್ ಗವರ್ನಮೆಂಟ್, ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್. 50% ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕಾಗಿರೋದು ಸ್ಟೇಟ್ ಗವರ್ನಮೆಂಟ್ ಮೈ ಲಾರ್ಡ್. ಇಲ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್ ತಗೊಂಡ್ಬಂದಿದ್ದಾರೆ. ಉಳಿದಿರೋ 50% ಏನಿದೆ
ಎಷ್ಟು ಜನ ಇದಾರೆ ಅಂತ ನೋಡ್ಬೇಕಲ್ಲ. ಟೋಟಲ್ ನಂಬರ್ ಆಫ್ ಪೋಸ್ಟ್
ಎಸ್
ಎಷ್ಟು?
ಮೈ ಲಾರ್ಡ್, ಡೀಟೈಲ್ಸ್ ಇರೋದು DDPU ಆಫೀಸ್ ಅಲ್ಲಿ ಅವ್ರ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಪ್ರಮೋಷನ್ ಕೊಟ್ಟಿದೀವಿ, ಎಷ್ಟು ಡೈರೆಕ್ಟ್ ಆರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇದೆ ಅನ್ನೋ ಎಲ್ಲ
ನಿಮಗೆ ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ ಕಾಲೇಜಲ್ಲಿ ಎಷ್ಟು ಜನ ಪ್ರಮೋಷನ್
ನಮ್ ಕಾಲೇಜಲ್ಲಿ ಇರೋದು ಆಲ್ರೆಡಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಅವರೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. ಅವ್ರ
ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಎಸ್ ಮೈ ಲಾರ್ಡ್, ಇನ್ ದ ಪೇಜ್ ನಂಬರ್ 21 ಮೈ ಲಾರ್ಡ್.
ಪೇಜ್ ನಂಬರ್
21. ಮೈ ಲಾರ್ಡ್ ಪ್ಲೀಸ್, ಇದ್ರಲ್ಲಿ ಒಂಚೂರು ಮಾರ್ಕ್ ಮಾಡಿದೀನಿ ಮೈ ಲಾರ್ಡ್. ಇಟ್ ಇಸ್ ನಾಟ್ ವಿಸಿಬಲ್ ಕ್ಲಿಯರ್ಲಿ.
ಹೇಳಿ
ಮೇಡಮ್.
BL ಸಂಯುಕ್ತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜ್ ಜಾಲಹಳ್ಳಿ.
ಪೇಜ್ ನಂಬರ್ 21.
ಕೊಡ್ರಿ ಅದೇನು.
So among them, ಇಲ್ಲಿ ಪ್ರಕಾರ ಈ ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ಪ್ರಕಾರ ಮೈ ಲಾರ್ಡ್ 13 ಪೋಸ್ಟ್, 21 ಲೆಕ್ಚರರ್ ಪೋಸ್ಟ್. ಉಳಿದಿರೋದೆಲ್ಲಾನು
ಗೋಪಾಲ್ ಅಂದ್ರೆ ಯಾರು? ಫಿಸಿಕಲ್ ಎಜುಕೇಶನ್ ಅದು ಲೆಕ್ಚರರ್ ಪೋಸ್ಟ್ ಅಲ್ವಲ್ಲ ಅದು?
ಮೈ ಲಾರ್ಡ್
ಗೋಪಾಲ.
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
Is that a lecturer post? Serial number 13.
Okay my lord, up to 23 it is lecturer post my lord. So
3 ಅಲ್ಲಮ್ಮ 21 ತಾನೆ. ಮ್ಯಾಥಮೆಟಿಕ್ಸ್ ಲಾಸ್ಟ್
22 ಹಿಂದಿ ಇದೆ ಅಲ್ವಾ ಮೈ ಲಾರ್ಡ್? ನೋ ಮೈ ಲಾರ್ಡ್, 20 up to 21 ಟೋಟಲ್ ಲೆಕ್ಚರರ್ ಪೋಸ್ಟ್. ಅದರಲ್ಲಿ ಅಪ್ ಟು 13 ಫುಲ್ ವೇಕೆನ್ಸಿ ಫಿಲ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು.
ಆ ವೇಕೆನ್ಸಿ 13 ಅಲ್ಲಿ ಒಂದು ಪೋಸ್ಟ್ ಮಾತ್ರ ಪ್ರಮೋಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅಂದ್ರೆ ಇನ್ನ 12 ಡೈರೆಕ್ಟ್ ಆರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಲ್ಲಿ ತಗೊಂಡ್ಬಂದಿದ್ದಾರೆ. ಡೈರೆಕ್ಟ್ ಎಕ್ವಿಪ್ಮೆಂಟ್ ಆರ್ ಟ್ರಾನ್ಸ್ಫರ್, ಡೈರೆಕ್ಟ್ ಅಥವಾ ಟ್ರಾನ್ಸ್ಫರ್ ನ ಆಲ್ರೆಡಿ ಫಿಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಉಳಿದಿರೋ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿರೋದು ಪ್ರಮೋಷನ್. ಈ 21 ಬರ್ತಿದೆ ಅಲ್ವಾ ಮೈ ಲಾರ್ಡ್ ಮ್ಯಾಥಮೆಟಿಕ್ಸ್, ಆ ಪೋಸ್ಟ್ ಬರೋದು ಪ್ರಮೋಷನಲ್ ವೇ. ಸೊ ಈ ಲಿಸ್ಟ್ ಆಲ್ರೆಡಿ ಅವ್ರ ಹತ್ರ ಇರುತ್ತೆ. ಇಲ್ಲಿ ಉಳಿದಿರೋ ಎಲ್ಲಾ ಪೋಸ್ಟ್ ನ ಅವ್ರ ಪ್ರಮೋಷನ್ ಮಾಡ್ಬೇಕು. ಈಗ ಆಲ್ರೆಡಿ ಎಲ್ಲಾ ಪೋಸ್ಟ್ ನ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ಯಾವ್ದು ಪ್ರಮೋಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಮೈ ಲಾರ್ಡ್. ಆನ್ ದಿಸ್ ಗ್ರೌಂಡ್ ಇದು ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ. ಈ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿನ ಟ್ರಾನ್ಸ್ಫರ್ ತರ್ತಾರೆ. ಸೊ ರೆಸಲ್ಯೂಷನ್ ಆಗಿದೆ ಮ್ಯಾನೇಜ್ಮೆಂಟ್
1 to 13, 1 to 12.
ಎಸ್ ಮೈ
ಹಿಂದಿ ಲೆಕ್ಚರರ್ ಇದೆಲ್ಲ ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್
ಡೈರೆಕ್ಟ್ ಆರ್ ಟ್ರಾನ್ಸ್ಫರ್
ಅಲ್ಲಮ್ಮ? 1 to 12 is it direct recruitment?
ಡೈರೆಕ್ಟ್. ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಡೈರೆಕ್ಟ್ or transfer?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
ಅದಕ್ಕೆ
ಒಂದೇ ಒಂದು ಮೈ ಲಾರ್ಡ್, ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ರವೀಂದ್ರನ್ 8 ಅದು ಒಂದು ಪ್ರಮೋಷನ್ 2013 ಅಲ್ಲಿ ಆಗಿರೋದು ಮೈ ಲಾರ್ಡ್. ಸೊ ಉಳಿದಿರೋ ಎಲ್ಲಾ ಪೋಸ್ಟ್ ಬಂದು ಅಂಡರ್ ದ ಪ್ರಮೋಷನಲ್ ವೇಕೆನ್ಸಿ. ಎಲ್ಲವನ್ನು ಪ್ರಮೋಷನ್ ಅಲ್ಲಿ ಅವರು ಫಿಲ್ ಮಾಡ್ಬೇಕು. ಫಿಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಒಂದು ಪ್ರೊಸೀಜರ್ ಇರುತ್ತೆ ಮೈ ಲಾರ್ಡ್. ಅವರು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ನ ಕನ್ಸಲ್ಟ್ ಮಾಡ್ಬೇಕು. ಯಾರು ನಿಮ್ಮಲ್ಲಿ
ನಂಬರ್ 9 ವೆಂಕಟರಮಣಪ್ಪ, ವೆಂಕಟರಮಣಪ್ಪ ಮತ್ತೆ ಅರ್ಚನಾ ಕುಮಾರಿ ಅವ್ರದೇನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಅಥವಾ ಪ್ರಮೋಷನ್?
ಇದ್ರಲ್ಲಿ ಅವರು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಕೊಡ್ಬೇಕಿತ್ತು ಮೈ ಲಾರ್ಡ್. ಮ್ಯಾಕ್ಸಿಮಮ್ ಆಫ್ ದೆಮ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇದೆ, ಕೆಲವರು ಪ್ರಮೋಷನ್ ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಇದೆ. ಆದ್ರೆ ಪ್ರಮೋಷನ್ ಇರೋದು ಮಾತ್ರ ರವೀಂದ್ರನ್ ಒಂದೇ.
ಎಸ್ ಮಿಸ್ಟರ್, ಪ್ಲೀಸ್ ಫರ್ನಿಶ್ ಇನ್ಫಾರ್ಮೇಶನ್. ಈ ಅನೆಕ್ಷರ್ R5 ಅಲ್ಲಿ ಇದೆಯಲ್ಲ,
ಇದು ಅವರು ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇಂದ ತಗೊಂಡಿದ್ದಾರೆ ಮೈ ಲಾರ್ಡ್. ಬಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದು ಕಾಪಿ ಇರುತ್ತೆ.
ಈ ಲೆಕ್ಚರರ್ ಪೋಸ್ಟ್ ಎಷ್ಟು ಪ್ರಮೋಷನ್, ಎಷ್ಟು ಟ್ರಾನ್ಸ್ಫರ್, ಎಷ್ಟು ಡೈರೆಕ್ಟ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್? ಯಾವಾಗ? ನಾಳೆ
ಮೈ ಲಾರ್ಡ್.
ಬರ್ಕೊಳ್ಳಿ
ಮೈ ಲಾರ್ಡ್.
No. If she is entitled to, we'll close it. We'll not keep the litigation alive. ತಿರ್ಗಾ ಇವ್ರು ಅಲ್ಲಿ ಹೋಗಿ ತಿರ್ಗಾ ಬಂದು ಎಲ್ಲಿಂದ ಇದರಲ್ಲಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಪೋಸ್ಟ್ ಇಲ್ಲ. Mister, you should accept that there's a post available for promotion. When there's a post available for promotion, if the management does not send it, how can she be held responsible? ಬೇರೆ ಯಾರನ್ನ ತಂದು ಕೂರ್ಸಿದ್ರೆ ಇವ್ರು ಅಲ್ಲೇ ಸ್ಟಾಗ್ನೇಟಿಂಗ್ ಲೈಫ್ ಲಾಂಗ್ ಅಲ್ಲೇ ಟೀಚರ್ ಆಗೇ ಇರ್ತಾರೆ. ಅಸಿಸ್ಟೆಂಟ್ ಟೀಚರಾ? ಅಸಿಸ್ಟೆಂಟ್ ಟೀಚರ್ ಆಗಿ.
My lord, already
After hearing after hearing the petitioner who has appeared in person and the learned AGA as well as the learned counsel for the respondent number 4, it is necessary to secure details as to how the post of lecturer in the respondent number 3 is filled up, as whether through promotion or through transfer or through direct recruitment. The learned AG is therefore directed to secure full particulars about the filling up of the post of lecturer in the respondent number 3 by day after tomorrow. This day after tomorrow. Dictating nilla aguthe Rachana Bharadwaj,
For dictating orders.
can you take it up maybe at 4:45? We're not done any headway through the list. Dictation will take at least 1 to 1.5 hours. So we'll take it up either at 4:45 or on some other day. ಯಾವತ್ತು ಫ್ರೀ ಆಗಿದೆ ನೋಡ್ರಿ. ಇವತ್ತೇನು ಆಗಂಗೆ ಕಾಣೋದಿಲ್ಲ ಡಿಕ್ಟೇಷನ್.
ಒಂದು ಸಜೆಸ್ಟ್ ಮಾಡ್ಬೋದಾ ನಾನು?
ರಿಸರ್ವ್ ಬೇಡ
ಅಲ್ಲ ಮಾಡಿ ಬೇಡ, ನಾನು ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ.
ಹಾಕಿದ್ರೆ ನೋಡಿದೆ. ಐ ಆಮ್ ರೆಡಿ ವಿತ್ ಡಿಕ್ಟೇಷನ್, but it will take at least 1.5 hours.
I understand.
So therefore I thought we'll
subject to your coming.
17th ಖಾಲಿ ಇದೆಯಾ? ನಾಳೆನೂ ಇದೆಯಾ? 15th 17th? 17th. The part of the judgment in my chamber.
Obliged. No, if there's any clarification of that.
If there's any clarification, I'll definitely call upon. There's only one clarification which I need. I'll call you, I will inform you. There's only one clarification as of.
Very good. For further hearing matters, serial number 33, Sri Mukanappa.
Kindly have it at 2:30 minutes.
Heard some time, my lord. Heard some time.
Yes.
Report. The respondent 5. Any possibility?
ನಿಂದು ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸರ್. Any possibility of settlement can ಹೇಳಿದ್ದು ಸರ್.
Kindly have it at
Last
2:30
time
minutes.
also.
Past 7 minutes.
2:30. Yes. So
Serial number 34.
Vijay Simha Reddy. Vijay Simha Reddy.
I appear for the petitioner on this matter.
For the respondent, my lord may kindly not mistake me. The inquiry documents on this file ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ. Today I may, if my lord will kindly have it on Wednesday or next Monday I will file it.
Learn counsel for the respondent number 3 and 4. Mistake ಏನು ಬರುತ್ತೆ ಸರ್? ಮಿಸ್ಟೇಕ್ ಏನು?
ಅದು ಬೆಳಗ್ಗೆಯಿಂದ ಹಂಗೆ ಆಗ್ತಿದೆ ಅಂದ್ರಲ್ಲ, ನಾನು ಅದ್ರಲ್ಲಿ ಸೇರ್ಕೊಂಡಿದ್ದೀನಿ. ಅದು
One submission. The documents he's speaking of is all part of the record already, my lord.
He says some documents.
ಬೇರೇನು ಇದೆ. ಅದಲ್ದೇನೆ inquiry documents ಅಲ್ಲದೆ ಬೇರೇನು ಇದೆ. ಎಲ್ಲ
I can't help it if lawyers want to avoid the court. I can't help it.
No, I'm sorry. That is not the intention. I'm sorry.
Serial number for disposal, serial number 35. Because
Lord, may kindly fix a date, my lord.
Some date is fixed, please. Because Rojipura.
I
appear for the respondents. Appear for the respondent.
I appear for 5 and 6 of the connected matters.
Because Rojipura. Anusha L.
This is a case, my lord.
ಅಲ್ಲ ತಗೋಬಹುದು ಅಂತ ತಗೋತೀನಿ. ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ I will not waste time.
We request for a short accommodation. We have engaged senior counsel Krishnamurthy. They want a short accommodation, a week's time maybe.
Madam, 2014, please have some concern for the litigant also.
No, my
The matter is remitted by the division bench. Earlier petitions have been allowed. The salary pertaining to the class 4 employing of engineering.
ಯಾವತ್ತು ಬೇಕು?
my lord, next week, meeting.
You
15th
please
or
pick a date of your choice. Two 2014.
16th or 17th.
ಕೊಡ್ರಿ ಯಾವತ್ತು ಬೇಕು ಅಂತ ಕೊಡ್ರಿ.
16,
2023
17,
ಇದೆಯಲ್ರಿ?
it's not possible.
2023 matters
15th
ಇದೆ.
it can be taken.
Connected ಇದೆಯಲ್ಲ ಅವತ್ತು ಹಾಕಿ. Yes. 16th,
We have some senior counsel.
15th.
Serial number 36.
But in some cases, interim order is.
Wherever interim orders are enforced, the same shall stand extended.
Final hearing matter, serial number 36. C. Shankar Reddy.
Not your lordship.
Respondent was filed an affidavit to complete the orders on the period which shows the respondent is not given sufficient. What is the response in the 2009 till the 2014 when the government order was modified?
On 5th, we have filed the affidavit, your lordship.
Yes. What does the affidavit say?
That no benefit was given, your lordship.
From the year 2009 till 2014?
Please, your lordship.
Yes.
Please. To brush up the memory of the court. Not petitioner.
Can I take it up for final disposal?
I am ready.
Are you ready? Are you ready?
Your lordship.
Will he come?
Please, your lordship.
He is ready?
Please.
Yes.
Not, this is a case of a contract employee. Not, she joined services of the first respondent not pollution control board way back in the year 1997. Right from 1997, it is on continuously working, not as a contract employee. Not at an earlier point of time, there were as many as 103 contract employees not in the pollution control board. They formed an association not, and filed a writ petition before this honorable court. Not seeking regularization of one of the reliefs not sought for in the writ petition. Not, during the pendency of the writ petition.
When was that?
Please, 2010, my lord.
38300.
38300 of 2010, my lord, is the writ petition that came to be filed, my lord, in the first instance. Not on annexure E, my lord, that your lordships can find from page 28. By an order dated 23rd February 2011, not an interim order came to be passed in the said writ petition, taking note of the fact that during the pendency of the writ petition, my lord, fresh notice by the honorable court, my lord, that certain of the contract employees had also made an application for direct recruitment at that particular point of time. And some of the contract employees, my lord, thinking that some favorable orders would be passed in the writ petition, they had not applied. Therefore, this honorable court, my lord, directed the first respondent board to collect, to take the applications of all those contract employees who have not applied also. For a moment, your lordships may kindly turn to the interim order that came to be passed, my lord. The second paragraph, my lord, that your lordships can find from page 29. Now, the second paragraph, my lord, would read, in the meanwhile, the pollution control board wants to fill up certain of the posts through direct recruitment. Certain of the contract employees have also applied for being considered for direct recruitment. However, thereafter, paragraph number 3. page 31.
Hmm.
From the above, it is clear that all the contract employees who are already working in the State Pollution Control Board would be given 4% weightage for each satisfactory completed year of service.
Hmm.
This benefit is applicable to all category of posts advertised on one-time basis against which they are working. The government order is issued for the benefit of the contract employees working in the contract employees does not qualify to apply for. The cases of the contract employees who have applied also will be considered, treating their applications having been made under the cadre and recruitment rules of 1992.
Hmm.
Actually, no prejudice will be caused to any of the contract employees who applied for the post of direct recruitment. Though it is the case of the contract employees that they have been appointed on contract basis to certain posts, same is disputed by the board. Sri Ajay Kumar Patil, learned advocate appearing on behalf of the State Pollution Control Board, submits that the board will be considering the case of the contract employees to regularize or case-to-case basis. Then your lordships may kindly refer to the next paragraph. Sri Patil further submits that the board will be extending time to file applications seeking appointment for direct recruitment till the 10th of March 2011. Said submission is recorded. It is open for any of the contract employees working in the State Pollution Control Board to file application if not already applied for direct recruitment to the respective posts. Such applications will be considered by the board, keeping in mind the government order dated so and so. However, the appointment order shall not be issued until further orders of the court. But, this is the interim order. This interim order was challenged before the division.
Please have a look at the government order.
The government order says that 4%
Considering the facts traversed in the
considering the facts traversed in the preamble, the government are pleased to accord approval for extension of weightage as 4% of the marks for each satisfactory completed year of service rounded up to the next integer, and age relaxation extended by government order bearing number so and so dated 5/8/2002 as amended time to time to those employees working on contract basis as on the date of the notification issued for direct recruitment who have not availed the said benefit earlier.
So, we are not availed the said benefit earlier.
Please.
So, for example, if for this notification, if you have availed the benefit,
Please.
once,
Please.
can you avail the same benefit for the next recruitment also is a question.
That question may not also request to be considered by the court.
Hmm.
Now, this particular interim order was challenged by the board before the division bench in a writ appeal.
Hmm.
That your lordships can find from page 34, annexure F.
Was this the interim order or the petition itself was disposed of?
It was an interim order, my lord.
Yes.
Petition was pending.
Hmm.
Not as against this interim order, not the matter went up to the division bench, not the division bench, as per annexure F, page 34, not was pleased to dispose of the writ appeal by an order dated 19th April 2012.
Yes.
Lord, paragraph number 36. Lord, the honorable division bench was pleased to extract paragraph page number 36, not ink page 36. That would be internal page 3 of the judgment. Your lordships may kindly refer to the paragraph number 3 that is in the bottom portion of the said page. The learned single judge has passed the following interim order. Lord, interim order of the learned single judge was extracted. Thereafter, your lordships may kindly turn to paragraph number 4. In the writ appeal in paragraph number 7, detailed data of number of posts, number of vacancies advertised, number of contract employees working, and number of contract employees applying for the said posts are furnished. In respect of assistant environment officer, 60 vacancies are notified for appointment. Then paragraph 5. In respect of assistant environment officer, 60 vacancies are notified. The number of contract employees working are 4. Out of them, 2 are eligible to apply for appointment of direct recruitment. In respect of the scientific assistant, 15 vacancies are notified. There are 4 contract employees. All 4 of them are employed. In respect of the stenographers, 4 vacancies are notified. There are no contract employees working in that cadre. In respect of junior data entry operator, 20 posts are notified and 14 contract employees are working, and out of them 8 applied. This is the post where we wanted to get appointed. In
Junior data entry operator.
Where are 20 posts, there are sanctioned 20 posts. 14 contract employees, my lord, are working, and out of them, 8 of them had applied, including my lord, the present petitioner. Then your lordships may kindly skip that particular portion, and your lordships may kindly refer to paragraph number 6. In respect of the posts where less number of contract workers as against number of vacancies notified, proportionate to the number unfilled, subject to the result of the writ petition. In other words, the appellant can fill up to 56 posts of assistant environment officers, 11 posts of scientific assistants, 4 posts of stenographers, 6 posts of junior data entry operators, and 9 posts of peon and watchman. The rest of the notified vacancies shall be kept subject to the result of the writ petition accordingly. Writ petition it should have been writ appeal is allowed. The interim direction given by the learned judge will continue to bind the appellant subject to the modification as indicated above. Now thereafter, my lord, the final order came to be passed in the said writ petition that your lordship can find from page 40. My lord, that would be annexure G, my lord.
Yes.
My lord, the relevant portion of the writ order, my lord, lordships may kindly refer to, my lord, the page 48. That would be internal page 9 of the order.
Yes.
It is unnumbered second paragraph in the page. This court, by interim order dated 23/2/2011, noticed that some of the contract employees had made applications for recruitment in pursuance to the notification dated 6/10/2010, and some had not made application, and the state government had also passed an order dated 12/11/2009, inter-alia, granting approval of extension of weightage at 4% marks for each satisfactorily completed year of service, rounded up to the next integer, and age relaxation extended by the government order dated 5/8/2002 as amended from time to time to those employees working on contract basis as on the date of notification issued for recruitment, who have not availed the said benefit earlier, and the said benefit shall be applicable to all categories of posts advertised on one-time basis against which they are working. Government also ordered that in case the total percentage after adding the weightage exceeded 100%, then it shall be limited to 100%. Having regard to the government order extending the weightage for the contract employees, this court permitted the contract employees working in the board to make application if they had not already made, and made such applications would be considered by the board keeping in mind the government order dated 12/11/2002 extending the weightage. This court had also observed that though the contract employees did not qualify to apply to the respective posts advertised as per the notification dated 6/10/2010, in view of the amended cadre and recruitment rules, and directed the board to consider the case of the contract employees who had applied, treating their applications as having been made under the cadre and recruitment rules of 1992, so as to avoid any prejudice that would be caused to the contract employees who have made an application for direct recruitment and were not qualified under the amended cadre and recruitment rules of the respondent board. In writ petition number so and so, the relief sought for by the petitioner is to stay the petition is that their case for regularization, if the process of recruitment continues, the very purpose for which their request for regularization as they would be denied the said benefit. Having regard to these circumstances, it is appropriate to answer the question whether the contract employees by the board are entitled for regularization. That your lordships may kindly skip, because that may not be the subject matter of the present writ petition. Lordship may kindly.
So petition also applied.
She also applied, but this particular weightage is not being given to her, stating that even prior to 2009, she had applied for a different post where she had claimed weightage and she was given weightage. Therefore, subsequent to 2009, if another recruitment process has begun, and in that recruitment process, she cannot be given that weightage. On that particular ground, my application has been rejected.
How was that weightage given without even a government order being passed at that point in time? ಅವಾಗ
ಅವಾಗಿತ್ತು ಕೊಡ್ಬೇಕು ಅಂತ ಇತ್ತು. That's the whole concept.
But what happened was,
1997
during the year 2002, I was also not working in the same pollution control board, but as a data entry operator. But data entry operator posts were not called. It was called for second division assistant. At that particular point of time, that one time was not there. Weightage for one time was not there. All contract employees are entitled for weightage was the general principle at that particular point of time as per the government order.
Until
For
they
the first
recruited.
time, in the year 2009, they made it one time. Therefore, prior to 2009, when I was working, from 1997, I have been working there. 2 times I have applied. On those 2 times, they have given me benefit of service weightage. Because at that particular point of time, there was no restriction as to number of attempts that you could have made.
Yes.
For the first time, it was introduced in the 2009. Therefore, they come to a conclusion that since you have already utilized at an earlier point of time prior to 2009, you are not entitled to take that benefit subsequent to 2009. Lord, this honorable court, Lord,
Please come at 2:30. You ready, no? Don't say you need an adjournment. Because that is what I have been doing since morning.
ಇದೆ.
Serial number 2 interim order may be.
All interim orders will wait.
We are not. But listen. It's a NOC, man.
My lords,
Ah,
serial number 39, my lords.
ah.
We are for the petitioners. My lord.
Thank you for the petitioner.
Petitioner, my lords.
My lord, also for the petitioner seeks time list after vacation.
My lords, on 21st, my lords.
Sorry,
My lords, on 21st, my lords.
sorry. Yes, next.
My lords, on 20,
Senior